Okay, you guys. Hey, welcome back to the live for the third time today.
Yeah.
We have Charmaine's with us, Ivy Rose is with us, and of course Travis. And Travis is on cam today. Yay! Finally
Right.
figured out that. And you got your cowboy hat on,
And he's in a different position than he was just a minute ago.
right?
2 seconds ago. Giddy up.
I was looking at that, going, "Wait a second, Travis."
No, that was
More?
me running
That was you running.
in
How
the
was you running
intro.
during the intro?
And where I was running to where I am now.
Right. I mean, he was old bridge guy, and now he's young bridge guy.
I was gonna say somehow I knew all of a sudden this atmosphere of hey, in and out.
Oh, thank you,
Charmaine.
Bree. Oh,
Okay.
Charmaine.
Okay, well, okay, so I'm gonna have to turn off the sound for that in just a second here, and that's fine with me because all you guys can. Adam wanted to ask Travis a question, but let me just quickly say that Candlin, I have not seen that name before, but welcome, Candlin. You got a free membership. Ruth, Deb K, AJ, you got a membership. Kyle Davis got a membership, and
Oh, the Rickroll. I love it.
one sec. Sorry. Jen P got one. Peace Train, Susan Silverstein, and Juju. Why does it look like? Hold on, 2 AJs got one. Oh no, that's her saying hello in that one. My bad. Okay,
Charmaine, that's really sweet of you.
You're welcome.
Charmaine, thank you so much.
Charmaine, I also saw you being generous in Tom Webster's live earlier. So, you know,
Funny story. He was like, with his last live, I donated like 5 memberships or something. So he sent me a message. And he's like, "That's so nice. Thank you, blah, blah, blah. But I prefer if you don't give memberships." And I can't remember why, but he had a really legitimate reason why. And I was like, gotcha. That's why when I did it today, I was like, this is a super chat. This is not gifted memberships. I apologize. It was funny. But he did have a really good reason. But I liked it.
Bill, what is it?
I'd have to go back in my messages and see.
Nah, don't do that.
Why don't you just share your screen and show all your messages with Tom Webster?
No. Aspen, where's your tattoo? Apparently, Aspen has a tattoo of Tom, or what was it? Tom Webster.
I was being jovial earlier, and I said that I said, oh, I just recently got a Tom Webster face tattoo, but Sonny, and because Sonny won't let me show my Sluther Vandross patch alives anymore. And then he was like, "Oh, someone should block you." And I was like, "Well,
I made my belly jiggle. It was a good belly laugh.
No, I got
someone has to make his audience laugh."
Oh, I think a lot of people laugh all the time.
Funny, you're muted.
I keep having to listen to Rick Astley 5 times so far. Okay, Adam, did you want to ask Travis that question?
I do. I have a quick question. And this is something that someone had mentioned to me, and I don't know the answer to. And I thought if anyone would, maybe it'll be Travis. But essentially, my thought process was that with the new charges, or whether they are additional charges, amended charges that came out today, when a defendant such as Rick Allen is presented with additional or amended charges, does that automatically warrant or an appearance in court to be formally charged with the new charges, typically within 48 to 72 hours, something along those lines? So my question is really, should we expect an unexpected court appearance early next week by Richard Allen?
No, probably not. I'm not an Indiana attorney, and I'm not versant in their specific procedures, but in federal court and the states, I am familiar with Oklahoma, Texas, Nevada, California. If the amended charges flow out of what is originally charged versus something completely new. Let's
Like
say,
Rex
an additional murder. Okay.
right, like Rex Sewerman.
So they're just tweaking it. Then no, you do not. But it is an issue that comes up a lot, that there's these new charges. And so defendants will frequently say, well, that's really not an amendment. It's a whole new charge. And you should have to go to the grand jury to get a new indictment. If it's federal court or the state, that's their practice to use the grand jury for felonies. Or if it's like Indiana, you should need a new probable cause affidavit. And then if they win on that, then yeah, you go through that whole process. But courts, if it flows out of the same criminal episode, the murder of 2 young girls, and they're just tweaking what crimes can come out of that, then no, you don't get a new arraignment. You don't need a new arraignment. Really what they're looking at, and when we go over to that pleading, if we do the motion to amend, add charges, or amend the charges, you'll see in there that they cover that there's plenty of time. That what the courts look at is it a surprise?
Okay.
And if it's not catching the defendant off guard, then the courts allow that. They'll allow it right up even during the trial to amend, as long as it's no surprise and no prejudice to the defendant. So no, that's a good question. I don't anticipate, unless there's something very unusual about Indiana procedure that says anytime that there's an amendment, you have to rearraign the defendant. I just don't.
And that's
based on their grounds for it, and showing the court why there's no surprise, there's no prejudice. I doubt very seriously that they have a procedure that requires a new arraignment. So no, I wouldn't anticipate that.
Right. And that was my question, is because I was like, how do we classify these as additional or amended? Because there were 2 murder counts and now there are 4. And I just didn't know if as a defendant, if Richard Allen had the constitutional right then to stand before the judge and be formally charged in the court for those new charges. But like you're saying, if it's just an amendment, then probably not. But of course, there was that part of me that selfishly was like, oh, should we expect an unexpected Richard Allen court appearance Monday?
No, I wouldn't think so.
Okay.
But is this an amendment? Because the old charges are still there. It's an additional.
Yeah, pull up the paragraph that talks about specifically what they're asking for. Is it number 7? I can't read that.
It says the state is asking the court for leave to file the amended charges because the charges were more accurately align the charging information with the causes discovery and probable cause affidavit. See Indiana Code 34-1-5A179. Because of the clarity of the discovery and probable cause affidavit, the defendant has been on notice since the beginning of this case.
Go up above for the previous page, whatever it is.
Okay. Well, and that last line could indicate that there's no need for a charging hearing, because it says he's been on notice since the beginning of the case.
Yeah.
Go up to what you said,
What does that
Travis?
mean exactly when they say they've been on notice since the beginning?
Because of the probable cause affidavit, they've been on notice of the facts of the underlying
Oh, okay.
case, and that Therefore, they should be aware of all possible criminal charges that could flow from those facts.
Okay. So they
So
they
let's
should have
say,
anticipated it.
what's that?
So basically, they should have anticipated this being a
No, it's
potential.
just that they're not being caught by surprise because the new charges don't require any additional facts outside of what was already in the PC affidavit.
Okay.
So let's say, well, manslaughter. Let's just say that they decide they want to plead a lesser included offense. And so they said, well, we've got more information and we're just not sure what the evidence is going to be, so on and so forth. Could be felony murder because of the kidnapping, could be just straight murder, intentional and knowing. But, you know, it's also reasonable that a jury could find it was reckless. Not going to happen under the facts of this case, hypothetical, reckless. We want to add the lesser included offense of manslaughter. There's no additional facts that would be needed for that outside of the probable cause affidavit. And they're just saying it's not surprise because they've had the PC from the beginning and we're not alleging anything that requires you to look outside the PC. And then they also mention that with respect to discovery also.
Right.
That's what they mean by that. It's a subtle difference.
They do specify also in like line 8, they say this amendment does not prejudice the defendant's substantial rights. And then they on line 9 they even say that the trial for this matter is 9 months away. Well, maybe sooner. Giving defense adequate time to prepare to defend the amended charges.
Yeah, scroll down. Trying to get to the point where they specify what they're adding or changing. It's down below.
It's the last one on the first page and then the second page.
Yeah. So yeah, if you read, really, it's 5, 6, and 7. Like I think the 3 of those together are like.
Okay, let's see. The charging information and probable cause in this matter reflect the charge of murder under 3542 1-1 subparagraph 2, commonly referred to as felony murder. Okay. Specifically that Richard Allen did kidnap victim 1 and victim 2 by force.
Which was the
in
original.
the process of committing that felony, both victim 1 and victim 2 were murdered. And then 6, the state hereby moves to amend the charging information to add additional counts. So they're leaving felony murder in place, which include murder under subparagraph 1 for both victim 1 and victim 2,
which is regular murder.
Regular murder. Scroll down below.
To the next page, Sonny.
Wow, we went way below. I got all this stuff moving across the screen. Oh, there's 7. There's not a continuation of 6 above that. Okay, that's not. The state is asking.
There should be. Victim 2 along with kidnapping under. Yeah, there is. It's cut off on Sonny's thing for some reason. You're muted, Sonny.
In here talking and freaking again. Anyways, yeah, like meaning it's the actual document.
I can't see it. Where is it?
Yeah.
But I don't see it either.
So when 6 ends, it goes on to the next page and it says with kidnapping under IC 3542 32 A and IC 3542 32 BK B 2A for both victim 1 and 2.
How come it's cut
And then
off
it goes on to
that?
7. Here, let me send you it again, Sunny, just in case.
Yeah, because
No, so I've got enough from that.
yeah, okay. But send it to me anyway, Adam.
So, all right. So there's been a lot of misunderstanding among a lot of different YouTube channels. Not yours, of course, because you have people like Adam and Ivy and Shar, but there's been
Okay,
a lot
you
of
can say you.
confusion about kidnapping and how it relates. And so felony murder in Indiana, typically felony murder is if you commit a felony, and can be
There it is.
any there we go. Okay. If you commit a felony and somebody dies in the course of that felony, so you go in and you rob a bank and your gun accidentally goes off and you kill your co-conspirator, your co-defendant, your gun accidentally goes off and it kills the I like movie analogies. So Pulp Fiction, they're taking that guy from the room those 3 or 4 guys are holed up in. They, kill everybody. The big brain on Brad, and there's one guy left. They bring him. They put him in the front seat. The gun, the back seat. The gun accidentally goes off, and his brains are, and blood are spread across the back of that car, and they, call Mr. Wolf. That's a death in the course of a kidnapping. And so that would be felony murder. Even though the gun accidentally went off, they would be charged with felony murder because they had kidnapped him to take him to see whoever the big guy was. Anyhow, that's an example of felony murder. In Indiana, it's codified in a statute, and there's specific felonies that the state of Indiana have decided to allow to be used for felony murder, others not. But one of them is kidnapping. So we call that an element. An element of the offense of felony murder in Indiana, you have to prove kidnapping. And it's technical, but the jury has to unanimously find that a kidnapping occurred. And if they do, then it can be felony murder. Felony murder is easier to prove. You don't have to show the intent. You don't have to show that you intended to shoot a person or kill a person. You just have to show that you have a person who's deceased, unalive, I guess we say on YouTube for whatever reason, but you have a person who's unalive in the course of a particular felony, kidnapping. You don't have to show that you intentionally shot the person like in Pulp Fiction. The gun went off and blew that kid's head off, and Mr. Wolf fixed it for him. But regular plain old murder, you got to show it's an intentional killing. Kidnapping is also an aggravating factor on murder. That aggravating factor, you have aggravating and mitigating, but kidnapping can be used as an aggravating factor to get either life without the possibility of parole and or the death penalty. So they may be doing this so that they can get the death penalty.
Well, since you brought that up, Travis, I sent Sunny a picture earlier. I did find where Brad Rosie actually, where he does say that he is DP certified or death penalty certified. And then if you look at that list that we were looking at on I think it was Charmaine, was it, or was it Ivy that was looking at the list?
It was
And
me.
Oh,
I know
yeah.
he says it on his website, but
it says, and if you look at the fine print on that list, it says that not everyone that's DP certified is on the list.
okay. I didn't get that
But
far.
here's where Rosie himself actually says that he is DP certified.
Mm-hmm.
So thank you to the person that sent me that earlier. And also in regards to the death penalty aspect of this, I found a list, and I'll send it to Sunny, but I found a list of what aggravating factors make a case in Indiana eligible for the death penalty. And I hadn't seen this list before, so I thought that was really cool. I forgot to send it to Sunny, but I will now.
Funny, you're muted again.
So it's something if
Well,
we want
so
to get,
while you're getting that to her, I've asked in the past in your channel while I was in chat, why didn't they file for the death penalty in this case? And no one had an answer. And I mean, the outrage about it, you'd expect it would,
Mm-hmm.
in a rural Indiana county, not seeking the death penalty, I would think, like in Texas, would be enough to get you unelected the next cycle.
Well, when was the last time there was a death penalty case? Because I mean,
well, they haven't put anyone to
y'all in
death
Texas,
since.
but you guys have a reputation.
It's
Oh,
been,
yeah.
I mean, the last person they put to death in Indiana, I believe was it like 2008, 2009? I can't remember. I looked it up, but it's been so long ago that I can't remember the exact
Well,
circumstance.
I'm not saying so. Wisconsin, for example, has
Was
no
it
death
Timothy
penalty.
McVeigh?
No,
So, but when there's a high-profile, horrendous case like the Stephen Avery case, there's always a thing come up, and it's happened in Illinois, just to the north. We need to bring back the death penalty, and this is the type of case that cries out for it, and it's from those conservative counties, and typically the smaller rural counties are ultra conservative, and those folks like the death penalty typically. And so even though it's not carried out, you can't get parole if you're on death row. The best you can ever do is get commuted to life without. So,
Okay.
I don't know. It just struck me funny. And then, remember, I just came into the case about October 11th, and
We're so grateful you did.
well,
Yes,
I'm
you are.
glad. I hope
Right.
I've helped some understand.
With what you just said, though, Travis, with the list that I pulled up, like you had said, you were wondering why no one had ever, why this wasn't a death penalty case before. When you look at the list that I have that we have on the screen now, the second bullet point, it literally includes felony murder as being an aggravant that can be used for the death penalty. It's just interesting that no one has actually specified. No one still to this day.
That thing's wrong. I'll just tell you that right now.
Well, this is from, just to let you know, I got this from Andrew Baldwin's website. This came from his
Defendant
law
intentionally
office
murdered
website.
the victim or while attempting or committing criminal deviant conduct, arson.
Is deviant a word?
Oh, okay. I misheard you. So it's not felony murder. Intentionally murdered. That's what they've added.
Okay, intentionally. Okay, thank you.
That's subparagraph 1 that they want to add. Intentional murder. Felony murder is not intentional. The defendant intentionally murdered, and then the aggravating factor is any of those things, and kidnapping.
Right. So that
Okay.
intentionally is the important word. Thank you, Travis.
So, and then that gets you to life without parole, or the death penalty. Now, the other thing that came up around the 11th is that Judge Gull mentioned somewhere, I don't think it was in a hearing or something, but somewhere it got mentioned, maybe Shar remembers, that I need to find a couple of death penalty qualified defendants. And I'm like, why do they need to be death penalty? And then I asked the questions again, what's the timeline? What's the time limit for the state filing an election? And somebody in chat said, oh, it's gone long by. And I researched that, and I couldn't find a specific time limit on when the state had to file a notice that we're going to seek. If the state seeks the death penalty, you have to send a notice to the judge, the defendant, and check this out, the Indiana Supreme Court.
Yes.
Because the Indiana Supreme Court then looks at it and goes, okay, is everybody in the system, prosecutors, defense lawyers, judge, is everybody equipped to handle this death penalty case?
Right.
And but it's also a way to get to life without parole, because in Indiana the max for a murder is 60.
Right. So when I was looking at the list that's on on the screen, and Travis, I agree with what you said 100%. And those are things that we've all talked about. The third one is and I don't want to be graphic, but like I was trying to look at what aggravating factors, like if you want to take away the kidnapping aspect, like what other things could make this a death penalty case. And this third one right there, for anyone that knows the gravity of the damage that was done to the girls, is this third one an aggravating factor? Because I think it could be argued that what happened to Libby specifically could be interpreted as an attempt to decapitate.
Yeah, it can. And the
Because I'll read
Nicole
it.
Bowen case, Garrett Kurtz, the state was trying to get life without parole on the table with that. Based on the coroner's report, the way she was tied up, that Kurtz was inflicting injuries upon her while she was still alive. And so they were going under torture. And then they ended up, because they said that, I assume, because they said they were looking at that, from my review of that case, Kurt's main concern was he wanted some sort of chance of making parole. And so he was wanting a lower number, 30 or 40, to become parole eligible much earlier. And then when they started indicating that they were going to be looking seriously at whether they could make a case under torture, he went ahead and worked out a deal for 55.
Right.
And that's where we are. So yeah, for sure they could, any one of those things. He's pretty much quoting the statute. They could have added that. Why they didn't, I don't know.
Should we read these just so that we can pull them off the screen?
Yeah.
And I'll read them if you want me to, Sonny.
Go ahead.
These are the aggravating, and like I said, I got this off of Andrew Baldwin's website. These are the aggravating circumstances required to impose the death penalty in the state of Indiana. It says another person hired the defendant to commit the murder. The defendant intentionally murdered the victim while attempting or committing criminal deviant conduct, arson, criminal organization activity, burglary, carjacking, rape, robbery, criminal confinement, child CP or SA, kidnapping or dealing cocaine or narcotic drugs. The defendant decapitated or attempted to decapitate or mutilated, burned, or tortured the victim while they were still alive. The defendant has a prior conviction for any of the following offenses against the same person they murdered: kidnapping, battery, SC, or criminal confinement. The defendant hired someone to commit the murder. The defendant intentionally or knowingly committed murder on school property in a building used mostly for education or within the presence of students or while classes were in session or in a structure or building rented or owned by a state educational institution or private or public post-secondary educational institution used primarily for education. The victim was a parole officer, judge, corrections officer, or corrections employee, home detention officer, probation officer, law enforcement officer, community corrections officer, or fireman, and the victim was performing their job duties or their actions while on the job motivated the murder. The defendant has a prior murder conviction. There's Garrett Curse's biggest problem with Ray Hannish. The defendant previously committed murder even if there was never a conviction. The defendant lay in wait to commit the murder. The defendant was on parole, on probation, in a county sheriff's custody or custody of the Department of Corrections when they committed the murder. The defendant intentionally discharged a firearm from a vehicle or into an inhabited dwelling. The defendant committed murder in a building used mainly for religious worship while people were present for their religious worship or education. The defendant dismembered the victims. The victim was a witness against the defendant, and the defendant murdered them so they could not testify. The victim was pregnant, and their murder caused the intentional killing of the fetus. The defendant murdered someone by unlawfully detonating an explosive to damage property or cause injuries to a person intentionally, or the victim was under 12 years old.
Yeah, so those are the aggravating circumstances. And, the jury has to find those. So AJ asks a few things in relation to that. Number 3 is easy. They'll file a speedy trial tomorrow, I would think, to trigger the 70 days. And then what's unknown about that is that time gets added to the 70 days that is due to delay of the defendant. So I don't know what number of days, if any, will be charged to them. We'd have to talk to an Indiana lawyer about that. But yeah, they'll file a speedy trial now. Do you think Judge Gull will recuse herself? Really unknown, based on just seeing how the courts reacted to certain things up to this point. I would say no, but I just did legal research coming into tonight. I found a case called Lopez, where the Supreme Court, so in Indiana, so we'll back up a little bit. Recall that Rosie filed a motion to disqualify, change the judge. And there's a rule in Indiana that provides for that if you can show bias of the judge by actions, and the actions can't be
rulings that you don't agree with. So, filing motions and having them all denied, that's not enough to show bias. You've got to show something else. But in Texas, and what Bob and Allie were saying in defense diaries, their jurisdiction, Illinois, when we file a motion to recuse, disqualify, change the judge, it's all the same thing. Another judge comes in that's appointed by the presiding judge of our district, appoints a different judge to hear that and decide whether there's bias or not. Not in Indiana. It's like the federal court. The trial court is supposed to review the motion objectively, not subjectively. And the court's not supposed to look at it, Lopez says, and say, oh, well, I think I can still be fair. They're supposed to look at it objectively and say, people on the outside looking at this, would they have a question about whether I can be fair or not? And then, the judge is supposed to decide upon that. And the standard of review is it's discretionary. And so it's an abuse of discretion standard, which is very, very difficult to overcome on appeal. And, another original action, if she decided not to recuse herself, would, be an impossibility. So they would have to request an interlocutory appeal, which the judge would have to agree to. I just really don't see the judge. I certainly don't see her recusing herself on her own, sua sponte. Bob Mata has been talking about that because she's gotten this election to the presiding judge position, the 2-year rotation, that she now has an easy out. I don't see her taking an easy out on the case, which would mean that they would have to say, Judge, we want to go forward with the motion to recuse, the motion to change judge. And they would go forward with that. I don't know what she would say after looking at it. The basis for the bias is that because of what the judge found and said about the lawyers, shows an implied bias. That's the argument. Whether she buys into that or not, I don't know. But that's a big one up in the air. Now, they could say strategically, essentially they're 2-0. The first petition regarding the court records and whatnot by PFD, Princess of Effing Darkness, she won that. The judge filed an order that mooted everything. And so the decision at the bottom of the line, of the bottom of the order says, we're going to deny the petition. But up above, if you read the substance of it, she filed an order. She fixed all these things. There's nothing really left to decide. While we're at it, we're going to explain once again our access to court records, ACR rules, and this is what you need to do. And it's clearly a win for PFD. And then this one, the judges are being replaced. She may just decide that, I've had enough of this. I'm going to recuse myself, not because of bias, not because of anything I did was wrong. I'm just too busy right now. My guess, and it's a total guess, it's even less, not an educated guess, clearly, but, I just don't see her letting go of this thing based on prior actions. I think my personal take on it is that she's been wanting to get onto the Indiana Supreme Court, filing, putting her hat in the ring every time there's a vacancy, and, not getting to that point. Maybe she kind of sees the writing on the wall and says, well, that's really not a path. Why am I taking all of this abuse, and why am I dealing with all of this for nothing? So who knows? So I don't know the exact answer on number 2, and we can come back to see what all of you all think about it. It doesn't take an attorney to really shed much light on number 2. You all probably have better views on it than I do. You've been in the thing much, much longer. And number 1, why do you think new charges were brought up now, which is the topic that we're on?
Muted. No wonder Travis isn't listening to me. Whew. I'm like, Travis, wait, I'm just trying to weigh in here. And then I'm like, wait, I'm muted again. I muted myself. Travis, I just wanted to say that one thing. Do you remember during the hearing today when he brought up about her being biased and whatever? And then Judge Rush was like, that's something that you need to prove and whatever. So I think that if they tried to, get the judge removed, that they would fail in that, because like you said, they'd have to prove bias. And you can tell today that they're like, no, you need to prove that she was biased. And you could tell that he kind of was like, well, I guess I can't really. Okay. Do you remember that?
Well, yeah, I do, which is why I think we all said as a panel that number 1 looked pretty solid. The attorneys were going to get reinstated, or at least I did.
Yeah.
And that number 2 and 3, I didn't see much chance at all. And I didn't see much, if any, chance at that before they granted oral argument. I didn't see much chance of it after the arguments. I've said that I think I said yesterday that I think what's going to happen is what's happened, that they're going to reinstate, and then there's a pending motion to change the judge. They're going to say, go forward with that, follow the procedure. That's not something that is required of the judge to do. Remember, original actions are only appropriate if the judge did something that she's required not to do, or the judge didn't do something that she's required to do.
Right.
One is mandamus, the first one, and the second is prohibition. So it was mandamus. The judge did something, removed the attorneys that she's required not to do, which is why the attorney for the court said this is discretionary, meaning not required to do it, meaning original action's not appropriate. That just wasn't sitting well with the 5 justices, that, or at least 4 of them, or at least 3 of them, because they said the majority
Yeah.
believe. But
Okay.
I'm sorry.
No, did I answer that, Sonny?
Yeah.
And for me, it seemed to boil down to the, what they really put their emphasis on was like what like Ivy had pointed out earlier this morning about that distinction between insubordination and ineffective assistance of counsel. And I think that's where they were able to say, Judge Gull's interpretation of those two things is not what we think it should have been, and that's why we're going to probably reinstate these attorneys. It'll be we'll know more when they
write
do their
yeah.
full written thing.
Right.
But
I was
the
just going
takeaway
to
I got
say,
from it,
on Sonny's point about the comment from Chief Justice Rush about, well, you have to prove that. There's not enough on its face. I don't think they were saying what you filed so far isn't good enough. I think what they were saying is what you filed, you got to carry through with, and you've got to give
Okay.
the court the opportunity to review it under cases like State v. Lopez, the rule that provides for the change of judge. You have to, just like she should have allowed you all to bring in witnesses and brief the argument that you can only remove us if we're ineffective in his defense, not for ethical violations. You need to let us, just like you you all are arguing, and we agree apparently that they didn't give you a full and fair opportunity, a structural error under Gonzalez to fix, get your arguments out there about why the conduct didn't meet the statute. You're not allowing her a full and fair opportunity to indicate why she is not biased simply because she feels that you are insubordinate. But to your point, yeah, are they insubordinate? And I'm very impressed with the justices honing in on those issues and directing the litigants, the attorneys, to the crux of the matter. Didn't get into, there wasn't a lot of squabbling about, what was said and the facts, the minutia. It was basically, okay, this process, did I say it right? This process that she undertook was, a structural flaw. And, let's get into the legal issues, as Shar kept saying over and over again. This is stuff that's matter of law. And, I think, it's a very astute point, Sonny, about that. What these judges asked kind of opened up into a window of what they were thinking and where they were going.
Right. And I think that gave the biggest clue to what happened today, was because I think that they determined, because they were like, look, Gold interpreted all of that as them being ineffective. The court did not agree with that. Therefore, I think they felt like, yes, she didn't do anything wrong, she wasn't biased, but her interpretation is not what we felt, and therefore they're going to be reinstated, and she now knows that's not the way that she should interpret it in the future.
Yeah. And go ahead.
Well, I don't know if I go that far. I kept hearing, if this had been done properly, if it goes back and you do a proper hearing, I kept hearing proper. So
was I being too
from those
kind
questions that she acted improperly.
But I think too that it's more about process than it was about, her finding. If that's
Absolutely. It was the manner in which she undertook it. But I also heard the word in describing, and I believe this was to counsel for the court, the first attorney to speak on behalf of the state in the court. I thought the question was to him, but the question he's talking about, well, they went in there and they did this. Yeah. And then she had her script. That's what they called it. Script. That told me that justice was not happy at all with the way that thing went down in chambers. And she had a script. And didn't one of the justices also bring up, no, I think it was the litigant, that she comes out and announces we've had a turn of events. I don't think a justice brought that up, but no, there wasn't too much digging down into how this isn't even an ethical violation. It was like you all have brought up. Is this being insubordinate? Is it being ineffective? And then in wheat, and then in wheat. And it's like, well, after that attorney, I thought did an excellent job with the record he had, laying out why the judge's ruling should stand on the removal.
Godwin, that guy?
Yeah.
Goodwin guy? Yeah.
Yeah. And I'm terrible with names. But after the third or fourth time that a justice is telling you, and then the Chief Justice Rush said, I don't think wheat is on all fours like you are saying it is. And when you hear that, it's like, get another case, whip out another case on them, because you've that dog ain't gonna hunt, how we say it in the South. And
So Travis, depending on how their opinion comes out and how it reads, am I wrong to assume that Judge Gall could now start the proper process to disqualify them? Like if she...
No, you're not wrong about that at all. She would have a really tough time. What the best he could come up with is that, well, even Rosie said that these photographs are going to pollute the jury pool and they're going to impact his client. The justices saw right through that stuff, and I think that hurt them credibility wise with the court. Both of them tried to allude to the fact that we don't know what Richard Allen wants. It's third hand that he wants these attorneys. That was their huge blunder. And the attorney for the relators, turned that back on him really quick. And then, the other thing that, they tried to, I lost my train of thought, but they tried to infer that hurt him, I thought, was this thing about...
You're talking about the crime scene pictures and how it...
Well, it was about, Char's comment that is this stuff really ineffective assistance of counsel? And Rosie made that comment in a different context. It was in chambers, and it was, or it may have been in a phone call that was documented in an email, but it's like the rumors that, they secretly leaked this stuff. And the response was, we're not going to leak that stuff. It hurts the defendant way more than it helps him. We don't want that stuff out there. You got to be nuts to think that. It wasn't in the context that rises to the level of ineffective assistance of counsel under Strickland. That's a whole different thing. And she can have as many hearings as they want. You're not wrong on that at all, Char, but and it will depend on the language of that.
Right.
But the way I read the order today, and the comments and questions from the 5 justices, I think it's a huge waste of time.
I agree.
That if they're going to try and show that, and it's no longer gross negligence, gross incompetence, these standards that she pulled out of thin air, the judge, it's ineffective. Are
And
they ineffective?
as I understood the arguments, those still wouldn't be grounds for a judge to remove counsel of choice.
I didn't get that at all. I got, that was the argument, and what in wheat that the possibility of being ineffective is enough, and they just completely shot that down. I think the writing's pretty damn clear on the wall. You got to be ineffective to remove a court-appointed attorney, and that you are not going to get the accidental, even the intentional release of discovery isn't ineffective in the defense of your client at trial.
Right.
It might be it might be contempt, and it might be an ethical violation, but that doesn't get you removed under the Sixth Amendment.
I think that's where
That's what I meant. I might have said it wrong.
I'm confused.
Ivy?
Sorry.
Go ahead,
ahead,
Ivy.
I talked over you again. What'd you say?
No, go ahead, Ivy.
Oh, I said, I think that's the part that so many people of the general public get confused about, is that just because there's a wrongdoing doesn't mean that it's appropriate to remove an attorney. So just saying that, well, they were negligent of leaving the pictures out or whatever, proving that isn't evidence that they should be removed. And I think a lot of, a big chunk of people were under that assumption.
Yeah.
You could tell when they were talking about half the truths. Okay, so Judge Franco felt like they were that they were misrepresenting how Richard Allen looked in jail, but part of that was true, part of it wasn't. Okay, so there was crime scene photos, but it all boiled down to the fact when she was talking but that's not enough to remove the lawyers.
It would have been a different it would have been a different scenario and story if in the investigation of the leak, or in Mitch Westerman's affidavit, even, if there was any indication that anyone was saying that this was something that was directed to be done by Baldwin or Rosie, that would be a completely different story. And I think that the suspicion of that was fair, but when there's no evidence to back it up, then you have to let it go.
Right.
And so, I don't think anyone has indicated that, Baldwin directed.
Yeah, I agree 100%. I could talk till I was blue in the face, and I did, about what she's complaining about, which was upsetting, understandably, to a lot of people. That crime scene photos got out that shouldn't have. But that's not ineffective. It's not grounds to remove, assuming that's what they were going to go with, and that's what the case law said from around the country, except in wheat. But wheat was a conflict case, and some things in law are just really difficult for lay people to understand. That it's wrong, but there's different remedies for that, and removal's not the proper remedy. And it's just one of those areas in law that, how can this be? They've, they're grossly negligent. They're incompetent. How could this not be grounds to remove? And what they're looking at is
shredded wheat.
How does that impact his defense at trial? Right. And again, I think the attorney for the court paid a high price in trying to argue that
Rosie's own admission, and he kept it up, and then, you know, the judges were cutting kind of through that anyway, I think, but it's like, well, you know, it's polluted the jury pool, but he was very, very effective in the manner in which he argued that case. Very good arguments on both sides, I felt.
Yeah.
I think, except the attorney for the state, the AG's office, I think she's very eloquent. But as you all have commented, I don't think she really added much to it. She kind of hurt the arguments of the court in a couple of places. Didn't really add overall, the thing at the very end, the judge asked, well, how do you see this playing out if we don't do anything? And then, I see my time's up. Saved by the bell. Chief Justice.
Right.
No, you can answer it. You go ahead, answer it. Well, they can file motions. Quote, they can file motions.
They can file motions.
Who can file motions?
Right.
And how do you file motions in a court where the judge has stricken your pleadings and ordered the clerk to remove them, and then backtracked from that and went with, well, they'll be received, but they're not official documents, which that can be done. But how do they file a motion? I mean, and I think that, you know, it's like, okay, so they do have an emergency situation here. They don't have any remedy other than us stepping in right now. But, you know, they were very clear that's all they're going to do is bring them back in and then reset. But I don't know what's going to happen, Shar, with that. But to me, even though the judge could do that, it would be an utter waste of time based on the comments and questioning from the justices. And, you know, we would need to see what's in the opinion, and it, you know, it could totally change that. But I would be surprised if they came out and said, you know, the standard in Indiana is ethical violations or ineffective or being insubordinate. I really don't think we're going to see that.
And what I think would be interesting is that, if not interesting in this case, but for people to understand, and you can correct me if I'm wrong, but if one of them were to come to court drunk or intoxicated, like that would get them kicked off way quicker than a picture getting leaked, right? A crime scene photo getting leaked, because that's more ineffective, even though that, in a lot of people's minds, is leaking the photo would be a much bigger deal. But being intoxicated will get you kicked off faster. But Adam, what were you going to say?
No, I was just going to say that, you know, for me, like when I was thinking about Baldwin and Rosie being removed from the case, it wasn't the ineffective wording that the justices clearly honed in on that I was thinking about so much as it was Gold's definition of gross negligence. And I guess, you know, I wasn't quite sure legally what gross negligence was defined as. Clearly, the Supreme Court did not feel like their definition of gross negligence and goals aligned. The other thing I was thinking about, like when I think of ineffective assistance of counsel, and I think this is something that still could end up playing into account, but it was not a question for the Supreme Court, is if Richard Allen were to go to trial, get convicted, I still think that the leaks happening from Baldwin's office could be an argument that Allen can use to file an appeal, because I think that, you know, he can then, because he's not kept to any burden. Like he can use that as an argument for an ineffective assistance of counsel appeal. It wasn't a question in front of the Supreme Court, but I think it could be a question in front of an appellate court.
But I think they would have to take into account the letter that Richard Allen wrote to the judge asking for them to remain, and that he was aware of the leaked photos. So I don't think so. Maybe I'm wrong. I'm just trying to be proactive in thinking what curveball is going to come.
It's almost like informed consent in a way,
Yeah.
that letter.
Yeah. So a couple of things. So
he could easily he was unaware
however
of
you want to phrase it, gross negligence, gross incompetence.
Good point, Anna.
It still could be that, but it's ineffective assistance of counsel, which means their performance in pretrial motions and hearings and at trial. So they could be grossly negligent in not hiring a ballistics expert. That's ineffective assistance of counsel. It's directly impacting the client's defense.
Absolutely. People have gone through an appeal.
Let me finish. So it could be that they're grossly negligent or they're grossly incompetent, but it's got to be on his defense. Letting out crime scene photos is insubordinate to the judge, but has nothing to do with the defense of the client. Zero. So that's number one. Then number two, what Ivy just said about on the rebuttal, Judge, I want to clarify one thing. When I said it would depend, can he bring, and they talked about PCR, post-conviction relief, which that's where you raise ineffective assistance of counsel, IAC. And he said, I want to clarify, because he knew he kind of gaffed a little bit when he wouldn't concede. Remember yesterday, be looking for concessions. They're going to try and get concessions out of these attorneys. I said it this morning, look for concessions. They were trying to get him to concede that either he has no IAC claim for what's occurred up to October 31st, or if he has an IAC claim. So he came back on rebuttal and said, no, if it's laid out, he has no IAC claim for the release of the photos, and these other three things got narrowed from 5 or 6 down to 3. He cannot raise that on IAC. I've been saying that for months to you guys. And I think that came up in the prosecutor's thing, and somebody started tossing that around, and it's bullshit. It's total waiver, informed consent. Yeah, I'm aware that might be something, but I still want these guys going on. And then he read the letter. I'm aware that these photos got out. He's explained it all to me. I still want these attorneys. There's no IAC claim here. But there would have been if they did nothing. And he said this would be a show trial. It'd be practice. Pretty strong words. And I think that got you to 4. That got you to a majority of the court saying we can't have a show trial. And he's right. He's got a great IAC claim now, in addition to structural error. And he's come back on rebuttal and acknowledged, no, he's got no IAC up to October 31st. And that's what put it over. But if he's convicted, I mean, you can plead anything, but typically in Indiana, the trial counsel does the direct appeal. They favor that. So trial counsel will never, in a direct appeal, claim ineffective assistance of counsel on themselves. You have to wait for PCR. But you're not going to see a post-conviction attorney with this record come in, and they're going to mention it, and they're going to detail that in the brief. Counsel for relators concedes that he would have no ineffective assistance of counsel claim based on these things. I think absolutely you're going to see that, and that'll put that issue to rest forever, hopefully.
Yeah, that was a great time. I remember that. It was like a boom moment.
Sitting here muted again.
Yeah.
Sorry, I was gonna say, Adam, you were gonna say something, and so what were you gonna say to Travis?
Travis really kind of covered what I was going to say, and I appreciate.
Okay.
I appreciate that his opinion on it. And I was really just going to say that like basically that people can file an ineffective assistance of counsel appeal for the smallest of things. I mean, I've even seen where they will file it for the fact that their lawyer talked them out of taking the stand in their own defense. And so I was just saying that the bar for like what you can use as your basis for an ineffective assistance of counsel appeal is low. Doesn't mean it'll get granted. You can use whatever excuse you want.
And you're absolutely correct on. You're absolutely correct on that 100%. People will throw out whatever, not taking the stand, and it's a dead bang loser because they put all of these safeguards in at the trial to make sure that can't be brought up. And so it's got to be major. So what happened in Texas is because we have a lot of people who are undocumented here in Texas, obviously. And so they were taking pleas, but they were not informing these people that were undocumented. They were getting, they were pleading to a felony and they were getting probation or a misdemeanor or family violence. They were not explaining the immigration consequences of taking that plea. And it was determined by the U.S. Supreme Court that that's ineffective. And so what happened is they redesigned all of the plea forms where it says, if you're not a U.S. citizen, do you understand this could, cause your deportation, removal. And so they, the court admonishes them, have you discussed with, they ask, are you a U.S. citizen? If not, has, your attorney explain to you, and, so very, very careful. But yeah, that was that one bar that some attorney pled somewhere about it. And, it's tough and it's a hard one to reach, but it's on post-conviction. You either have Brady, ineffective assistance of counsel, IAC, or new evidence. That's it. And so, yeah, you gotta throw everything you can and see what sticks. You are correct, Adam, that post-conviction counsel is going to come in and they may argue it, but it's pretty much been gutted. But that's true of anything. It's true that, they could try and say, well, he didn't testify and the court didn't explain that to him enough or whatever. And, they can argue it, but I'm talking about a potentially viable argument. It's over now. They can plead anything they want in a post-conviction if he's convicted, but it's not going to have any meat on it.
Travis, we talked about this earlier, but AJ asked a question, and I was glad that Sonny kept it up on the screen because I would like to know your opinion on this. But Shar, she said, well, she's asking Charmaine. So Charmaine, you too.
You said Travis.
What does the new defense do now? Do they just resign? Do they join the old team? Do they give all their info?
That's a great question. Well, first thing you do is submit a bill. That's the first thing they're going to do. The order, so they'll either, they'll submit a bill and then file a motion to withdraw unless the court beats them to it. But they'll say, in light of the
Findings, yeah.
the order today, the published order, we're hereby withdrawing, because you need to officially get off the case. And, the judge could do it, but so they're going to submit a bill. They're going to find out, they're going to file a motion to withdraw, or they will contact the court and ask, do you want us to file does the judge want us to file a motion, or is the judge going to handle that, or what should we do? They'll be off. No, they won't be working with the other attorneys on the case in an official capacity. I'm sure that the lawyers will coordinate, especially about this latest motion to transfer. If that's what it was, I think it was called a motion to transfer. The ones where the new attorneys went to the prison and found what they found and couldn't effectively meet with their client to have attorney-client communications.
Hannibal Lecter.
They'll talk more about that, and because he moved after Baldwin and Rosie were removed from the case?
Yeah.
Remember, it was like the 27th of December.
Thank you. So they haven't been out there yet, and then they need to let the judge, they need to figure out how do we carry forward with that, and then what they're going to do on the Frank's motion and memorandum, and what they're going to do for the motion to exclude the ballistics.
Right. Which I would assume we'll probably get a lot of those pretty quickly. But is there a world where like the new, like I'm not, this isn't wishful thinking on my part. I'm just curious, like, is there a world where they can request to stay on the case and be added to the defense team? Like, could they approach Rosie and Baldwin and like want to work with them?
Absolutely. They're both state employees, I believe, part of the state of Indiana, or county employees, I think, part of that county's public defender system. So they won't be submitting a bill, will they? They're salaried employees, both of them, aren't they?
Yeah.
But having 4 attorneys would take away from the overall budget, I would think. I don't think that's likely at all for court-appointed attorneys.
Yeah, so court-appointed, what they call pauper counsel, I heard that term once in the arguments today. Court-appointed pauper counsel in Indiana, they're paid an hourly rate. But a defender's office can assist them in different ways. And if they say, hey, we'd like to stay on the case, Baldwin, Rosie, whoever's the primary counsel, we call the first chair, whoever's the main attorney, we'd like to stay on and help you to whatever extent. They could stay on that way, but it would have to be with the agreement of Baldwin, Rosie, and
The court probably, right?
well, no, court really didn't get a say in it, but Richard Allen.
Okay.
I just want to say Shibby. Shibby says when Supreme Court hearing started, I thought good old boys club, but it turned into Avengers Endgame. I think that they're pissed and gonna reprimand Gull. I don't think so. What I took away from it was this: is that they believe that Judge Frangel, obviously, she felt that she was in the right, but that proper process really wasn't followed and she overstepped her bounds, but she didn't do it intentionally. So I just think it's kind of like, okay, she thought she did this, but not like it's like, well, let's give you a big ass spanking because I don't think it's something like that. Do you? I just took it as,
I think it's another one of those things we need to wait for the more complete, full decision, because they did reprimand her quite clearly in the on the first petition on how to.
Yes.
I mean, I phrased them as bitch slaps. They bitch slapped her a couple of times in that first order. They expect the judges to comply with this stuff, and she should know. And even though she tried to, lay that on the clerk, they weren't buying that. But there's a couple of phrases in there where, she was reprimanded about it, not directly, indirectly, but, it's clear who they were talking to. And so I don't think they're going to be very rough on the court in the detailed decision, but like Adam was saying, going into the arguments this morning, or was that Aspen? No, it was Adam. Adam said going into the arguments that, and I think after the recap, this is a case that is going to be taught in law schools. It's going to be taught in the ethics course. It's going to be taught in the trial practice, criminal trial practice clinics. It's going to be talked about at the judicial conferences that they have. It might even end up in the Indiana State Judicial Manual. This is the standard for removing court-appointed counsel. Whatever that standard gets stated as, but I'm pretty sure it's going to say it needs to be ineffective assistance of counsel without regard to negligence or intentional, but things like not showing up to court hearings, not doing the right things you need to do to properly defend a death penalty case, violations of protective orders and ethical violations doesn't cut it. You need to send those. You need to either have a contempt hearing, and there still could be a contempt hearing. We didn't talk about that. Shar asked, and others have asked, can they go forward with a proper process to disqualify Rosie and Baldwin? I don't think so, based after the comments, but the judge could proceed on contempt violations of the order, especially the most recent one. The ones that are a year old, I assume they're a year old. That's the way they were represented in court today. I don't know how that would look. It doesn't show she's biased. She has the right to do that. She can also send a bar complaint to the state bar about if she thinks they're ethical violations, or for that matter, the prosecuting attorney can. Those are still on the table, but
I know for myself, I personally feel like, I feel like it would be the same disservice if they were to pursue if she were to pursue trying to get Baldwin and Rosie removed once again from this case, I think it would be tit for tat, the same as if they were to then continue to try to get her removed from this case without her being the one that wants to leave. Like, so I think whoever were to be the one that takes that first shot, it's just going to be dirty. Because, I feel like, like they're both, I think both parties are in a position now where they can just say, you know what, let's
move on with their
let's
case.
move on. And I think that was the Supreme Court's goal. And I don't think if this were brought back to the Supreme Court's attention, they would have any qualms about squashing that beef.
I think
Yeah, I'd like to get everybody's comments on that. I was actually thinking about that before coming on because I knew it was going to come up. And some others have a different viewpoint about moving forward right away with the pending motion to change judge that Rosie filed. My honest to goodness thoughts were, if it were me, I would not proceed with that. I'd just let it sit out there. I would not gloat when I went into the next in-person hearing. I'd be professional. I would act as though none of this would happen. It's
right.
a
You still wipe your feet at the door,
like professionals do,
right.
that have to work together, like chiefs of police that don't necessarily agree with district attorneys, defense attorneys that don't necessarily agree with prosecutors. You don't need to like the person, but you need to get along and work because of the vital importance of that system. And that would be me because, again, they're 2-0 on these original actions for all intents and purposes. Even though it says denied at the end of the first one, they got what they wanted on that. And even though it's denied in part or granted in part, denied in part on this one, they got what they wanted. In my experience over the last 37, 38 years, when you do go up and get an appellate court of some sort or a senior judge to evaluate something and you're proved right, it's almost an advantage with that judge. They work very diligently hard not to screw up again. That was my personal view on it, but I think that's something all of you all should give your comments on. And then also as part of that, number two, do you think, how would it look if the judge proceeded on a contempt hearing?
My brain just went like south, but on the contempt part, on a contempt hearing. Sorry.
Yeah.
What's it?
Do you think that she will? What do you think? What are your thoughts about if they all go back and then she starts the hearing for like contempt or misdoings or whatever for the attorneys?
Oh,
And that'll be the first shot that they were talking about. You know,
I just
The first
personally
what?
think
what?
What did you say, Charmaine? The first what?
The first shot, like they were just saying, whoever decides to go down that road,
Yeah.
is kind of taking the first
like
dirty
yeah,
pool shot, right? Instead of just acting like professionals and carrying on and trying to get this whole ordeal back on track.
right?
Whoever's going to deviate from that at this point would be kind of playing dirty
Yeah.
pool. And
Right.
I
Well, the
don't
first thing that,
disagree.
well,
sorry,
Sorry.
Charmaine.
That's all good.
I just think that they should
Yeah.
exactly what Travis said. To be honest,
Yeah.
professionals,
Yeah.
move on. Let's get this case rolling again. At the end of the day, the jury's going to decide whatever the prosecution has for evidence, whatever whatever they want to lay out, the whole Odinism thing. At the end of the day, like I said, that's all I'm seeing is let's just get this case going back on course.
Right.
I just
Yeah.
hope that this doesn't make them like hypersensitive if
Right.
Judge Gull rules against them. You know what I mean? And it might seem unfair. At what point are they going to jump on that? You know what I
Right.
mean? Like,
Think that she's being unfair again or not doing the right thing again, and
yeah.
Right.
that's my little bit of a worry there too.
And
Because-
isn't the legal term when you work towards a common goal with people that have opposite goals than you, isn't it called mediation?
Yeah.
But no, I agree with you. And but it's like, but then if they don't take if the motion to remove Gull off of or leave it alone, is that the first shot? So it's like again, people are going to argue it however that they best feel their current opinion aligns with what's happening. That's the sad thing.
Or just
You know
how
how-
they perceive what they're hearing and what
Exactly.
it is going to be a little bit strange. I'm not going to lie. No matter what, professionals or not, the whole
Yeah.
public knows what went down here, and that there's, they feel like there's going to be that little bit of animosity, whether it's true or not. Whether I'm sure Judge Gull can sit back and go, okay, look, okay, I might not have won the war, type of thing, but hey, you know what? Let's go back, whatever, and treat it, like, okay, well, welcome back, Rosie Baldwin. I mean,
I made your favorite
personally,
dinner.
yeah. Well, the thing is that we all know, regardless, we're human beings, and no matter what, if somebody burned me in life, do you think I'm gonna forget that? Do I,
No,
but can I move forward fairly?
I know that Sunny does not forget that.
No,
I have
right?
a list of people in my phone that she does
I was
not.
going to say, so is her block
Okay.
list. I'm well aware of that.
Yeah. I asked, that's very, very compelling, Sonny. But I asked Bob and Allie to comment on this. That if they don't remove the judge, which they clearly are not doing, to explain that as professionals, it's not going to be awkward. It's not going to be. We deal with that all the time.
Yeah. Okay.
And criminal trials are not mediation. It's war, and pretrial are battles. And you win battles, but it's a war because we have an adversarial system, unlike in Italy, which is a collaborative system. The prosecutor isn't called the prosecutor in Italy, and a lot of South America, they're called the presenter. They're supposed to present to the court both sides. And a lot of Europe is that way. But in the UK, the Commonwealth countries like Canada, the US, we have an adversarial system. And it's exactly what it means. You're adversaries. And our belief in an adversarial system is that that is the best way to get to the truth. Have both sides in an ethical manner, battling it out and slugging it out, and that the truth rises to the top in an adversarial system. And we're used to that. I couldn't do family law because the emotions and fighting over forks and knives, literally, I handled a few family cases and very early in my career and haven't touched one in 35 plus years because I just can't handle the
the emotions between the litigants, I get bogged down in it. But good matrimonial lawyers, they go in, battle it out with the other side. And I'm putting aside, dirty, sneaky, unethical stuff. Yeah, they go in a black book of mine, regardless of the type of case. But battling it out with the prosecutor time and time again, it shocks people that, man, after that trial, you guys were, having a drink together that evening, or I saw you guys at lunch 2 days after the trial. What's that all about? It's not that awkward. It's not that difficult. It's not like, family commotion and,
Yeah, I get what you're saying. I get what you're
it we're used to it. We're expected to be zealous advocates in the courtroom. And then when you walk out the door, you golf together, fish, do
Right.
whatever. Every county, they have what they call bench bar events. Prosecutors are there, defense attorneys, judges, and everybody gets along fabulously. And
right. Because
and then you gird your loins or whatever, and you walk through the doors to do battle. And when you finish for the day, you take your armor off, and you become a normal person again, or I'd like to think so. But I can understand why a lot of people think, oh, this is going to be awkward, or this is going to be really, really difficult, or and if they don't gloat, and I don't think they will, yeah, they can run forward. But
you don't think Rosie will puff out his chest?
don't know. I mean,
Yeah, I get what
he
you're
I have a question about this topic real quick. So I haven't seen this myself because I'm not an attorney and I don't know how to access these things, but on Twitter or X or whatever, there was a filing for the case by the new attorneys where at least parts of the exhibits were made confidential without what is it, ACR?
yes.
Basically with not following the rules and procedures laid out in the first original action.
Yeah, I asked
And
you guys about that yesterday. That my understanding was
mean
there was
today?
an affidavit attached to that motion that was sealed by the judge,
Oh
and
yeah.
I didn't know if she's in compliance with the order or not. I don't know, but
they're
that's
saying
one of the
that
things I was interested in.
that's all I'm going off of is Kara's Twitter or Weineke's Twitter. So, and there, of course, there hasn't been like an update. It may have gotten fixed, but she said that the exhibit was there, and then it wasn't there. There was no ACR paper with it, but it wasn't clear who removed or changed it. So then, let's say that is true. So then my question would be, do you guys think that little thing, does that change any of your opinions on how this may go, considering that if that is true, they're not following what the court said with that? It's almost, if that is true, it's almost like is that a pushback against the court? I mean, that wouldn't be very smart, but
That's
No.
what I said the other day. It seems to me like she really doesn't think she's doing anything wrong, though just how quickly she sealed this
And
next
that's
one.
why she's not on the Supreme Court, right?
Well, Shar, seriously, that would be a major area of concern, and it was a concern laid out by PFD on saying she hasn't mooted everything. She said specifically in the response to the opposition that was filed on behalf of Judge Gull, that it was something to, you know, there's a pattern here, and we don't think, in essence, we don't think she gets it based on what we've seen so far. And the court obviously disagreed and said, no, it's mooted, and we're going to clarify it for, they didn't say her, but they clarified what they expect moving forward. It would be beyond pretty dumb if the first thing off the bat, right out of the chute, the new attorneys file this motion and attach an affidavit, and it gets sealed. The only way that thing could be sealed is if the clerk brings it to the court's attention and the court says, I want this sealed. I mean, potentially there could be some order that the judge gave to the clerk. Anything that contains this, I want you to seal, but I doubt that, because it wasn't sealed. It was available for a little bit and then became unavailable. The only person that could do that is the judge of the court.
So, but I mean, so many times today, there are so many justices and even, you know, the AG mentioned how sparse the record is in this case, but they had denied that first writ or muted it, whatever. But then they acknowledged again today many, many times that there's basically no record to go off of in this case, and they're not doing anything about it. I don't understand that.
Yeah, I agree. I want to know that too.
Which made the attorney for the state from the AG's office, her first minute and a half, you know, was so bizarre. You know, we don't have what you all need. You know, you don't have what you need, and we are interested in your caseload, and you know, there's just not the record here for you all to be able to decide, and da 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 da. And I'm thinking the whole time, well, whose fault is that?
Well, exactly. And why did you deny
it? Wasn't for Rosie, you know, and they got that in there. I can't remember when he got it in, but he did. Must have been on a rebuttal, because he said, well, you know, it was because, you know, we got this thing filed in 30 days. And, you know, even though they were reluctant and they weren't going to give us the transcript, we got the transcript. The record we have is what we submitted to you. And I'm thinking, why are you arguing this? The judge, and it didn't really come up directly today, but I think the court was very, very concerned about the way the trial court was trying to manipulate the record.
Right, but they had already denied that first writ of mandamus. So, I mean, but she's still not complying. You know what I mean? Even though it was denied, they were going to clarify things, but I don't know if they ever did. But it's clear that there's still an issue with the record, obviously. And then she seals this latest filing by the new attorneys. So there's a disconnect.
Yeah, I don't know whoever tweeted that. Assuming it's true, it's, you know, going to be very, very concerning, and the judge may be up against PFD again. So be it. But you know,
From what
it's hard to say, but they were abundantly clear in that first order, even though it says denied at the end, that they expect that form to be filed to state specifically why it's being sealed.
Yeah. Sorry, Ivy was going to say something to you.
in Kara's Twitter, that's like my new my new source I have to cite, CARE's Twitter. She said that the next step would probably be in the lower courts. I can't remember if she said interlocutory. I'd have to pull it up again, but she
Oh, yeah, I know
definitely
that word.
told somebody that there wouldn't be another original action type of thing.
It'd be an interlocutory appeal.
Let me see if I can pull it up real quick.
Which
She's going to be on Defense Diaries tomorrow too. I'm sure that question will come up.
and while Ivy's pulling that up, the interlocutory thing is something that we talked about before court started this morning, because it was something I was interested in. So I was proud of myself when it got brought up a few times during court, because almost being a lawyer, I was like, oh well, maybe I'll almost get brought up. But when they brought it up, I was like, oh, honorary degree. But that was mentioned before this went up to the Supreme Court. And part of the argument against that being a thing with the interlocutory thing was that it would create such an adverse delay in this case. So to take that road now, I think would be highly disadvantaged. I just think it would be kind of hypocritical in a way. When you said, well, we're not going to take that action because it'll create a delay. Here we're given the opportunity to go 70 days to a speedy trial, and then if you file an interlocutory appeal, you're basically saying, oops, we were just kidding.
Well, the thing is, though, on the interlocutory appeal, to get one, you have to get the trial judge to agree to it, to certify it. And so that's what they laid out in their brief, that we don't have any other remedy other than original action, because not only will she not talk to us about, a certification for an interlocutory appeal, she won't even file our briefs, and she won't even give us a transcript of the proceeding. What chance do we have of getting her to certify this? She thinks she's right. And then the other thing was, that was the argument, really more so by the state, but part of it was from the court. The justices kept asking, well, what do you see happening? And nobody had an answer except the attorney for the state at the very end said, well, quote, they can file motions, unquote. And that wasn't an answer. It was probably an answer that Chief Justice Rush was very, very happy to get, because she knew when she went into conference that whichever justices were kind of opposed to granting at least the first part, it's like, well, they didn't have an answer for us. So, and we think we're not going to have a show trial. We're not going to have practice. But so that was a problem for the opposing side, the state and the court. They didn't lay out a plan that was practical on what Richard Allen could do to be heard on his choice of counsel. And that's why we're at where we are.
So I found it on Twitter and on X. And she says that the Supreme Court, in the original action, it said that they would have to go through the trial court and then the appeals process. And then there's some conversation. What's interesting, though, is that Allen Superior Court responded and says the Indiana Supreme Court issued an order on February 7th, 2017, stating that only final orders and judgments in criminal cases were to be made available on my case. And then Weineke responds and says, except the exhibits attached to the motion still must be reflected on the CCS, which, side note, like, that was part of the issue in the first place, is they didn't seem to understand that, like, the CCS is the record. It has to be on there. So the rest of what Weineke said is, yet when I go to my case using my attorney access, I only see a motion and no exhibits. But the exhibits were there this morning, and now they have disappeared. Rule 5 of the Indiana rules on the access to court records requires an ACR form to be filed with individual records that are marked confidential. Here, we not only have no ACR form, we have no record that an exhibit has ever been filed. Every filing into a case must be reflected on the CCS. And then there's like a little screenshot, I think, of
The unraveling.
yeah, no,
That guy?
of it looks like, I don't know what that is. It's something about the attorney's access to things.
Oh, okay.
And then Luke Nicholas said, surely the first step is a motion in the original court using the Supreme Court as the ruling, their ruling as the authority. So basically going to the original court and saying, hey, you're not doing this right, and we're citing the Supreme Court ruling as the evidence for that. And if that doesn't work, then interlocutory. And she said, yeah, that's basically right.
So basically, you know, who's going to do that? If it were me and I decided, yeah, I'm not going to proceed with the recusal motion that's pending, I'm just going to let that sit out there. I'm going to pretend like everything prior to today never happened. I'm going to file my speedy trial motion tomorrow. And on that, you know, I'd have somebody because I believe anybody in the public or the press can complain about that.
Yeah.
And
actually, I think that's what happened to originally get that the document dump back in June. I think that's what happened.
Yeah, wasn't it a motion by the press? And you guys aren't the press, by the way. Just remember that. The judge can lock up any one of you anytime she doesn't like what you do.
It was by Kevin Greenlee from Murder Sheet.
Was it him or the press association?
It was Kevin Greenlee. It was Kevin Greenlee from Murder Sheet requested it, and his name was mentioned in court. It was mentioned in the court filing,
Lord Greenlee.
Court documents. Yeah.
So what have they been saying?
Oh, I have no idea.
Or do we not talk about other channels in here?
No. I mean, it's fine. They were in court today, but I've not heard. I'm sure
I listened to both their episodes.
I
listened to both of them, and it's basically what we've all been trying to say in the past several weeks. I wish I could remember. There was something that annoyed me that I was like, oh, what? Like, I don't know. I can't remember what it was now, but it seemed maybe not disingenuous, but like looking at things with 2020 vision, or what is that? What's that saying? Basically, like,
and
yeah, there you go.
I really appreciate your insight on that, Ivy, because from what I've been hearing, and it's from people like you, and talking about it not in the typical YouTube channel drama way. Oh, do you hear what they're saying over there? And bringing personalities into it. But I don't watch their channel. I thought they were a bit sanctimonious about when the first thing came out, and telling people, don't look up this person. No, don't go out there and search who the person was that unlived himself. Don't be doing that. And we did this, and we contacted both sides, and we contacted the police. And it's just like, this is the most sanctimonious, self-serving bunch of drool I've ever heard. And so I haven't listened to them since. I'm not saying anybody else shouldn't, but
They weren't even able to find.
But I've been hearing the last few weeks that, we are right, and they're not going to be reinstated. What they did is so atrocious.
No, they switched their tune around.
When?
The last few. I listened to those two and then like a couple of ones before that, and they were like, well, we think after we've talked to some people, we think that they're probably going to be reinstated, but we don't know about Gull.
I don't even know who you guys are talking about.
Murder Sheet.
Oh, geez. Okay.
Oh, MS is that who you guys are talking about? Okay.
Well, I admire somebody that can admit when they're wrong. That's probably too strong. Listen, anybody that's listening, and if Murder Sheet's
They
listening,
admit they were wrong.
these are my personal
changed their
views, not
opinion.
the view of the channel. I apologize.
It's okay.
This has
Don't
nothing to
apologize.
do with Sonny and Aspen, although I've heard Adam say things like that. But Sonny and Aspen, this is me personally
Adam
from
says
that
it.
one episode. And so
You're
let me
not
just
wrong,
get back
Travis.
to it.
My opinion is if you cannot find a picture of McClelland's half boner funny, I don't want to be friends with you.
Hey, which, that's not him.
See, we don't need Adam for humor here. I knew it.
But Ivy, that's not him, right?
Is it not? Either way, it's still
not-
funny to
not
me.
I trust me.
I didn't know
wanted
that.
it to be. I wanted it to be so bad because it's hilarious. But
Was
that's
it
not.
Photoshop?
That's not actually a picture of McClelland.
No,
That was
I
taken
totally
off
did
of
not
the
know that.
internet.
Kind of
How do you know, Adam? How
What,
do you
Charmaine?
know? You need to tell us. How do you know?
I researched it very extensively.
Oh my goodness.
No, I did. Though. I found the original picture and I was like, oh my goodness, I thought it was McClelland too, and it's not.
Okay.
Texas Rangers.
So Greeno is asking Sonny and Aspen,
Greeno.
but let's do this around the table. What is the most shocking event you saw today? Probably
I think
that
it's a-
video. Oh, go ahead.
I was gonna say, I think it's about to hear Ivy talk to Greeno.
Oh,
I'm kidding.
what?
I'm kidding.
Actually, I'm not gonna lie. I saw the most funniest video prior to this live, and you were in it, Greeno. You were doing dance moves and all that, and anyways, it was funny. And I was
Please tell me they were rosy dance moves.
well, it was Rosie, and then it was BG Richard Allen, and then at the end it was Greeno doing this dance move. But if it wasn't for a copyrighted song, it was freaking hilarious because it was just about the dance moves. And you guys remember when BG is holding the pool cue in his hand and he's doing this weird ass jig going down. Anyways, but in all fairness, seriously, so what is the most shocking event you saw today? Who do you want to start with? Ivy.
I wasn't really shocked. I kind of thought, I'm not sure if I would have been shocked with much, to be honest, but I've kind of leaned towards that they were going to be reinstated. I wasn't really sure about Gull. I guess there's kind of a little bit of a shock that they're going to have to go back together. I guess if I had to pick the biggest shock of the day, it was the first few questions of Gull's side when the judges started asking them, and then I was like, oh shit, here it goes. This is not how I thought this was going to start out, because they came out kind of like guns blazing a little bit more than I thought they would. So I guess that's my moment.
Adam.
I think for me the most overall shocking thing I saw was how poorly I thought that all three of the attorneys that presented did. I thought that, I've said this a few times now, I thought that Mark Lehman started off really shaky. I think he got flustered really quickly off the bat. I think he recovered pretty well. I don't think it was a great argument. And then I thought that both attorneys that argued for Gull were completely lackluster and unimpressive. And so I was impressed mainly with the I was really impressed with the judges, with the Supreme Court judges, and how prepared they were to go into this case, and how fair I felt like they fielded and yielded their questions and concerns.
Now that I think about that, did that fourth judge even talk? Now that I think about it,
They all talked at one point. I think one of them was like at the very end. It was like finally, like, he was like, "Hi, by the way."
Okay. Shar?
Well, aside from the amount of times that Gull's lawyer insisted on bringing up wheat,
I was
But
gonna say,
wait,
I was the most
Holy-
floored, obviously, with how quickly they published their order. Like, I couldn't believe it.
oh
I
yeah,
left to finally do some work, and all of a sudden it popped up, and I was like, "Holy shit!" And I had to run
I'm gonna
back.
change mine to that.
I was gonna
Only in
say-
Delphi.
I was literally saying the same thing. I was like, I'm sitting here going, like, there was nothing really shocking to me besides what Charmaine just said, was how fast. I mean, like, we literally did a 48-minute live, got off. As soon as we got off, within a couple of minutes, boom, published order. And we're like, okay, live again. So I would say that was probably the most shocking too. So that's going to be my answer. What about you, Travis?
Well, Shar stole my number one.
Did she? What's number
But
two
I
then?
shouldn't have been shocked because Maggie Smith, when I asked her, she was the main attorney on the first petition, how long it would be for them to rule. She said exactly what happened, that, well, it's so rare, it's difficult to tell, but more recently, they've issued a very, very quick order with kind of a one-liner that they're going to come out with a more detailed thing. And I mentioned that at the end before I had to leave, but I thought it was going to take I thought it was going to be at least 7 to 10 days to get this one, given that they issued a full order on the first petition in 21 days. But since Shar stole that one, I kind of have two. One is that the chief judge brought up the recent motion to transfer,
Yeah.
and that she was aware of it. She alluded to things in there that there were still problems. She's a sharp cookie, as Adam mentioned, like all of them are. They were clearly aware that motion, to an extent, undermined one of the grounds that Gull found to remove them. The other thing that was a bit shocking to me is that Richard Allen's wife was in the gallery in one of the reserve seats.
Oh, was she?
Mm-hmm.
I didn't.
Yeah, I didn't know that.
Yeah.
Any word on her, like any of her reactions or anything like that?
No, we need to go over there, and like defense diaries. Bob was there. I know he knows her, who she is. I don't know if he was able to see her reactions. I'm sure he was glued to, when you're sitting in the courtroom, you're looking over here, and you could see it when that camera view is on the litigants and not the courts.
I guess, yeah.
She puts her hand over, acknowledging that judge who had the question about, well, since we're here, not too concerned. Let us be worried about our docket and
That was awesome.
how many cases we have, but since we're here, but it's hard. You're looking at all five and you're moving around and focusing on their questions. So I don't know if he was able to get her play by play is, looking at her reactions. For most folks who don't have the benefit of being in a channel and listening to smart folks like you and have it explained to them, what an appellate argument is. It's completely different than a trial, as everybody who watched it certainly is aware of now. I'm sure they would have briefed her about it, but you guys heard the questions, and I know that some of you could have answered them very, very well, but we are talking at a subatomic level of legal issues. Insubordinate, gross negligence, ineffective assistance of counsel, and all of the baggage that the term is it ineffective. Just that one word in quotes, ineffective, has a ton of baggage underneath it, but that all the 5 justices and the 3 attorneys clearly aware of. And, it's just something for most lay people that do attend, and which is why we don't have our clients at appellate court hearings. It's just they come away with impressions that, you just can't take. This one, I think, was pretty clear cut. I think most people felt that number 1 was going to happen. I think everybody on the panel after the show, me and Ivy and Aspen, or was it Adam this morning, whoever it was, and Sonny.
Probably Adam. He's more of a morning person.
Almost the lawyer Adam, I'm pretty sure, was this morning. And, everybody was thumbs up on number 1. And, 3 was a throwaway that was just put in order to be able to argue that this had the impact of destroying strategy because they had caught the state flat-footed. And 2 was, well, how's that going to work? And a lot of people fashioned, even some of the attorneys that have channels kind of bought into that. Well, you can't, and I didn't have a chance to listen to that attorney from Indiana you mentioned, Sonny.
Mark Lopez.
Yeah, but how's this going to work? It was a much tougher road to go on number 2 than number 1. Did we cover everybody on the most shocking? I'm sorry, I should have.
I was going to say, because so Greeno says I'm confused because he said about the day. And so I think we were all caught up in the Supreme Court and this was a question that we needed to go back to anyway, because
I forgot about that part too.
Because AJ had asked, but we'll get to this. We'll get to the thing that I'm just about to say after we go to the most shocking. Was when AJ said, "Why did those documents drop all of a sudden today?" But Greeno says, I'm confused. The most shocking, because I agree with Ivy on the guns blazing more than I thought. But what about the 4 murder charges against Allen, intentional homicide under 3542,
Right.
plus the 2 kidnaps? So what was more shocking to you guys, first of all?
Remember, Frank said that Nick McClellan was in the Supreme Court hearing. So, clearly he'd written this before, but, so like
how it was going.
When was this written? Well, I mean, it takes a while for things to hit my
One
case.
of them stated the 13th.
So that's interesting. So it's like, did it just happen to hit my case?
The exact beautiful time moment.
Because Nick McClellan was he wasn't in his office filing this today. He was in the Supreme Court room. He was in the Supreme Court hearing room, listening to the oral arguments.
Okay, who's tearing up paper or eating a snack or something? I heard it.
Not me.
Somebody. Travis, is that you? Are you eating the doggy food? Huh?
I mean, honestly, the murder charges, I don't know why, but it didn't surprise me at
Same.
all. Like, not even a little. Not even a smidge.
I
Not
think
even the timing of it. I was like, well, that big, but this is Delphi, right? So I was like, okay.
so. I was more shocked. If I had to pick between the two, I was more shocked of how fast the decision came down
Yeah.
versus the charges, because I think it's because we talked about it before, and how with Travis, and he had said like that, they can add on or whatever these charges or whatever it was, amend them or whatever it was. So it's kind of like, oh, okay. I think I was more shocked the fact that they came down
Yeah,
today with the Supreme Court stuff going on,
absolutely.
you know. So yeah.
I agree with you, Sunny.
So let's see. So Greeno says, yeah, but for two victims, isn't that a double jeopardy? Trying for Xing both girls twice?
I thought so too, but there's and Travis can answer this better, but there's a lot of precedent for about bringing multiple murder charges against the same defendant for the same victims. One case that I heard, that I was told earlier today when I was asking the same question, was a case that the Shenandoah case is one where there were two victims and they brought 4 counts of murder against them.
Travis, did you want to take that one?
It's not unusual at all to
You're the one that-
plead in the alternative. So felony murder. Now, the way what they're asking, we'd have to go back to that pleading again, to the very bottom, 6, 7, and 8, I think it is. I think that they've couched it. Didn't they couch it in the alternative?
1 second. Sorry, Travis. Good night, Charmaine. Charmaine needs to get going, guys.
Okay. Good night, guys. Thank
Love
you.
you. Thank you.
Hey,
Thank
Charmaine,
you.
I love you.
Bye, Charmaine.
You're still not getting ketchup chips. You owe me a lot more than that, Aspen.
Yeah, right.
Charmaine has been so mean to me today. I just want to say that.
Oh,
Charmaine
my
is so mean to
That's
me.
why, that's why Travis's camera is off, is because he's eating ketchup chips.
That's right. Or hickory sticks.
Yeah.
Okay. Good night.
Okay. Good night, guys. So go ahead, Travis. Sorry about that. And you want me to pull that back up again? Number which one?
Yeah, I think they're pleading it on the alternative, which means, but let's just put aside that for a second. So at trial, the jury's going to be instructed that you can find them guilty on felony murder and you can find them guilty on intentional murder, but they can't be sentenced twice for it. In other words, jury can come back guilty on all of that, but in sentencing, the judge can only sentence them for one of the crimes, which is always going to be the more serious one. And then adding that charge, I think, gives them a pathway. They want a pathway for life without possibility of parole. And then that plays into plea negotiation. They could be doing it for a path forward on death penalty, but really doesn't make much sense. It's easier to prove felony murder, and you have to have the kidnapping for the felony murder. It's easy because you don't have to prove that it was an intentional killing. All you have to prove is there's a kidnapping and a death occurred, but maybe they're concerned that because of the evidence, maybe they're concerned that that a jury might believe that they went along voluntarily to the spot and were unalived, whatever term we're using now, to avoid trouble with our host, that once they got to that location, that's when the intent formed, or when, all of a sudden things flipped around. Adam, almost a lawyer, has commented in the past that it's almost a logical impossibility, and Sonny's commented about this also, that given what has been released to the public, the video and the bridge guy, et cetera, and you all that have dug deep into this to the extent that you can, and where that location on the bridge is versus the general area of the crime scene, you know, there's just no way that this happened without the victims being taken there against their will, whether that verbal threat or gunpoint or whatever. But so one reason could be they started thinking about it, or maybe they saw another case in Indiana or a surrounding state where a jury acquitted or hung up, it had to be retried because one or two jurors got hung up on, I think he or she did all of the things to make the victim in the case unalive, but to me, you just didn't prove kidnapping or whatever the underlying felony might be, and so they want an alternative. And it can also be that it opens up a pathway under Indiana law. It's both kidnapping can form the basis to have felony murder, and it can also be an aggravating circumstance, which Adam, almost a lawyer, took us through earlier from Baldwin's website, what can be capital murder. And capital murder gets you the penalty of either life without possibility of parole or even the death penalty. And it can get you to that higher punishment as an aggravating factor. There was also some other things that Adam, almost a lawyer, pointed out in terms of, and I'm not going to get into detail, but there was some things about the way the victims may have been treated or so on and so forth post-mortem that can get you to that. So I'm not sure the timing of it. Not sure. Of course, the state would say, if asked about it, if it came up in court, it had nothing to do with the events of today. People can take that for whatever. I guess, we kind of just have to wait and see what they end up doing with it. A lot of times in these types of cases, they'll add life without parole or death penalty even to try and end up with a plea, because the stakes are much, much higher. Of course, does anybody know the way parole works on, if you get 60 years, are you parole eligible after 30 in Indiana? Let's just assume that, unless Adam, almost a lawyer, do you know, or Ivy or Sonny?
I'm not sure how parole works in Indiana, other than I know that that 30, actually, that might be right. I remember looking into it with Garrett Kurtz, but I have to remember. I can't remember what I figured out at this point. Granted, we've also been
figuring out on Garrett that it was half the time at least to become parole eligible. So my recollection is Mr. Allen's late 50s.
Thinking about Kagan Klein, doesn't he have to do wasn't it 3/4 or something? You have to serve 85. Thank you, because that's what I was going to say. Thank you, Greeno. 85% of violent crimes before eligible for parole.
Okay.
There's an expert right there.
Yeah, that's why I was saying Greeno.
I'm just playing Greeno.
So,
it's true.
Probably not an incentive to get him to take a plea, life without parole, not much difference for him. He's late 50s, right?
Yeah.
Yeah, he's 51, I think, at this point. September
Yeah.
9th is his birthday.
Yeah.
He's how old?
51.
I think he's 51 or 52.
Okay. What's 48 and
No.
52?
He's either 50 or 51 because his birthday was September 9th.
Okay, so 48's the minimum on a 60-year sentence. So that's what, 100? He'd be 98 or 100 before he's parole eligible. So life without parole is not a goal. So it could either be pathway to death penalty, which would put substantially more pressure on. It becomes much more of a gamble to go to trial than just 60 max and no death penalty on the table. Or it could be that something popped up in their preparation that said, we better not risk the chance of someone getting hung up on this kidnapping thing, and that we prove everything else to them, because you can prove by circumstantial evidence from the crime scene photos and the autopsies and all the other stuff that's attendant with a murder case. You can prove intent from circumstantial evidence. So that could be it. They would need to do it as quickly as possible so they didn't run into a risk of being prejudiced or surprised to the defendants, because maybe they filed it today because they saw the writing on the wall. They knew that number one was going to be granted. They were going to have to be dealing with these lawyers, and they knew that tomorrow there was going to be, well, they didn't know that the decision was going to come out today. They were probably thinking a week or two, but they probably saw the writing on the wall that they were coming back, and that as soon as they were officially back, which was today, they'd be filing a speedy trial motion, which now is only 70 days notice. Whoever posted that question, I'm kind of thinking out loud here. They filed it today because they thought they were coming back and they wanted to file it before they could file their 70-day speedy trial request. And so it's like, we didn't delay. We thought it was going to be October, November. And then that's what we were operating on. And we went ahead and filed it anyway. So they kind of wrote that thing. If you look at the top few paragraphs, they kind of wrote that thing. It would apply whether new counsel stayed and it was going to be a November trial date, or in my view, with hindsight being 2020, they wrote it also in the event that Rosie and Baldwin were reinstated.
Well, and let me ask you, Travis, what do you think as far as how, I mean, even if they wrote that intentionally, in case that things went the way that they did today, how would that really impact the defense, the approach the defense takes to mount a defense? I mean, does it really have a significant impact?
No. Well, obviously, if they add death, it's a whole new ball game.
Right. Which again, no one has actually given anyone notice that they're putting death on the table yet. Because
they had to go through this pathway to get to putting death, which was why I was asking when I first became associated with you guys in chat, why aren't they seeking the death penalty in this thing?
But there were aggravating.
As everybody in that community is supposedly outraged, why isn't the death penalty on the table there, and no one had a good answer. And then what's the deadline for? Well, they had to take this step if they want to get to the death penalty. I don't really think that's the case. So assuming the death penalty is not going to end up popping up, then no, it doesn't really impact. They've laid out under subparagraph 1. If you scroll down to the bottom of that page, right now they're charged with subparagraph 2, felony murder.
Where you want me to go, Travis? Sorry.
Down to paragraph 6, the bottom. There you go. Moves to amend the charging information to add additional counts, and which include murder under subparagraph 1, 3242 1-1, subparagraph 1 for both victim 1 and victim 2, along, and then go down to the top of the next page.
Yeah, I'll have to pull that one up. Oops.
Okay. So that's harder to prove. You got to prove that's, intentional killing. But the only reason why you add kidnapping to that is to get to life without parole or death penalty.
Darn it. Stop.
So it's interesting.
This one? Sorry, trying to find the right window. Oh, nope, that's not it. 1 second. Got too many things open here. Trying to go to number 7.
No, the top, you're going to the.
Yeah, you want me to go to the top?
Simulation of 6 at the very top.
Yeah, which is, I think, right here.
Yeah, with kidnapping under 3542.32-A and B2A. I don't know what those say. I don't know if one of those are just the kidnapping ways you can commit kidnapping, or if those are the aggravating cause for life without parole or death penalty.
Unindicated co-conspirator.
Unindicted co-conspirator. I think that's more about me droning on and on than old age.
Damn, you know you're getting older when you fall asleep in your chair waiting on the live. Travis, is that waiting on the live? Was he referring to you, Travis? Is that what you're saying? Oh, Travis lost his voice. Travis, can't hear you.
No, he wasn't referring to me. That was self-deprecating humor.
That was.
Oh, hey, we love self-deprecating humor here. We specialize in it. I feel like no one's going to make fun of me better than I can make fun of myself.
Exactly.
Yeah, no, it's clear from the very beginning when you have the kidnapping as an aggravating circumstance, you can go for life without parole and or the death penalty. So I don't have anything to add to that.
Good. Okay. Oh, AJ's heading to bed and waiting for y'all to come on. Well, we've been on 3 times today.
Well, AJ, thanks for your questions earlier. They were great. Hope I answered them, and good night.
Yeah. Well, I was going to say, Ivy, did you fall asleep or are you still there?
No, I'm having my nightly snack and dealing with a needy dog.
Oh, okay. Well, I was going to say,
that's like the 3rd time today that dog's been needy.
She's a very needy dog. She was I'm losing my train of thought right now. A pandemic puppy. So, and I work at home, and she's fine all day. But as soon as I get on the phone with somebody or have my
attention elsewhere, that's when she gets needy.
Okay.
So
Oh, of course.
Your Ivy, your dog has been needy 5 times less than I have been today.
Well, as long as she can beat you. That's all I
Yeah,
ask
there's
for.
Travis. Travis, what's your dog's name?
I'm a pandemic puppy too.
This one's Henry.
Henry.
There's little Henry.
Henry. Restless. Love Shack. Okay, I was having the Love Shack in my head. Henry. Henry. Restless. Okay. So what's the other one's name?
Oh, so I wanted everybody to show their uniform patches. I ordered my patches today to put on my
I'm Henry.
uniform.
Are Odinist patches?
Yeah.
Well, apparently in Indiana, you can put whatever patch you want on. No, I'm not
I didn't
an
get the memo to
Odinist
get a patch. So I
or a
don't have
Northern European pagan, but I'm going to do that one on my left shoulder.
Oh,
Oh yeah. Bullhorns. Okay.
And then
Is that
this
Texas
I'm going to
Longhorn?
put on my
Yeah,
right
Longhorn.
shoulder.
Oh, what does that one say? Oh, Texas Rangers.
Ranger.
Department of Public Safety.
That's
Nice,
the
nice.
official badge of the Rangers, which I don't know if people know, but that's a Mexican peso, an old one from the
Oh, I didn't know
1800s. And then it's sawed out. They saw out in between the peso.
Oh,
I
that's
didn't know that.
Oh,
That's cool.
So those are my patches.
I have an
I have a-
important question for
I have a
Travis.
hat that says porn star. Let me get it. I'll be right back.
Travis, who is your college sports team that you're affiliated with? I assume you have one.
The Yale Bulldogs and
Oh.
the Pepperdine Waves.
Not what I expected. So no Texas teams?
Pardon?
No Texas teams?
Well, I didn't go to UT, but of course everybody else did around here. So, by default, my wife's family is from, they're big UT fans and Michigan fans. So, for football, I pretty much had to adopt them, Michigan and UT.
Well, anybody against OU, I'm a fan of. So I'm sure that includes them.
Oh, then you'd love it around here when Michigan winning a national championship, and hearing the outrage about Harbaugh being suspended, and is he going to the NFL? Is he gonna stay with Michigan? And so yeah, that's who I root for. And so we have one game a year when Yale plays Harvard. That's the Ivy League just in sports isn't what it used to be. But
Yeah. You can't have everything. You can't have smarts and brawn or whatever goes into sporting.
Duke does pretty good. Who's your team?
I'm at Oklahoma State.
Oh, yeah. Okay. T-Boone,
Go Pokes.
old T-Boone's place.
Mm-hmm.
Yeah.
You guys are talking about shit. I don't have no clue what you guys are talking about.
Honey just smiles and laughs and says, yeah, I know.
Yeah. Now, just quickly, I want to say this. Kat, Travis, you don't know who Kat was, but he passed away sadly. Has it been a year? Has it been over a year now, Greeno?
It's been 2 years.
Has it been 2
Almost.
years? It's amazing. Yeah, I guess. Anyways, Kat was, hugely into the Delphi case, loved by a lot of people. And anyways, so Greeno, the way I'll think about it is that Kat is up there with Abby and Libby, basically nudging each other, going, "Look at this shit that's going on down
I was
there."
going to say, I hope Kat is up there looking down saying, God damn it, it wasn't Thomas Bruce.
Right. But I mean, again, but my heart still goes out to anyone that was personally friends with Kat, because that it hits different.
Yeah, Kat's
So,
he's a great guy.
Yeah.
Yeah.
But like Doug Carter says,
His hat trying not to get kicked out.
yeah,
Yeah.
yeah, because there was a couple deaths back to back, pretty much. There, can't think of the other
Bruiser.
person. Bruce. Okay, yeah. On there. But anyways, sorry about. I know you're missing your buddy there, because Greeno and Kat, did a lot of stuff together. And but anyways, like I said, try to look at it. I guess now from the side of they're going, glad I don't got to deal with that shit anymore because they're in a better place, honestly.
Right.
It's sad because on Earth here we kind of it's different, right? Nobody wants to lose anybody. Death sucks, but it's sadly the circle of life and stuff like that. But you know,
Oh well, trust me. I mean, when the Odin stuff came out, you know how much I wish that Blaine, had been around because I mean, he wasn't as well known as Kat, of course,
I think
but
so.
we became friends with Blaine, was Flint Farmer's nephew, and he passed away October 16th. Richard Allen was arrested October 28th, and I was like, Blaine, thank you. But could you now come down and give us some assistance? Because
Yeah,
we've talked about runes and Odinism and all of this stuff with you for months, and now you're gone and you're not here to tell us about it, and here we're all having to talk about it.
Yeah, we didn't know. You're talking about Blaine, right?
Because he was part of, he was sons of Odin, and
Yeah, I miss that dude. I miss Big Red like crazy. When people just connect, and with Blaine, we felt like we knew him for a long time, even though it was only a few short months. But
we were the only ones looking. We were the only ones talking about runes and these gangs and different organizations and we talked about Odinism because we talked about oh my gosh, what's his name? Ashley Garth,
Kurt
not Kurtz.
Mathis.
no, what's his face?
Think more Mike. Think more like Michael. What's his name? Would they go after?
I don't know what that means.
Wait, are you talking about
the
one that was?
Oh my goodness, what's his name? Yes, I'm talking about Karina's case, but
yeah, you're talking about what's his?
Oh, Gabe Ellis.
Thank you.
Who?
Gabe
Ellis.
Ellis.
Gabe Ellis, thank you, because he was an Odinist.
Mm-hmm.
Mm-hmm.
There's
we were talking about that in September of last year, and here then fast forward, and we're all like, oh, Odinism, and all of those lives are still there. If anyone wants to go back and watch them,
yeah,
we talked about it night after night.
Yeah,
I've been down that rabbit hole. That's why it drives me crazy when people haven't been following the case very long. I know that I don't agree with the Odinist theory, and I know it's been stretched, but it drives me crazy when people act like it's never been mentioned before. Like this is something they completely pulled out of their ass.
No,
Right.
It's been mentioned many times.
Well, it's even like Ivy. Sorry, Sonny.
No, go ahead.
I would say it's like Ivy. Even like I found those screenshots that between you and I from a year ago, where we were talking about the F symbol, and I was like, see,
we even got the shape pretty damn close.
Not new things.
Yeah, and that's it was actually amazing to me too. I just want to say how many people act or seem to not even have a clue about the Odinism being talked about, and I'm like, right? Like, I mean, you guys are that deep into Delphi, like. Everyone knows that Odinism was talked about multiple times. The thing is that, and I heard, like Mike Patty's into Odinism and but the thing is that for me, when I heard about the Odinism, it just wasn't something that I really wanted to entertain. It just seemed like this whole different rabbit hole to me that was like, what? Cult stuff? Wait, what? And I just never really entertained that angle so much. And then we talked about that stuff with Blaine because, again, it was kind of like out of my realm. What do you mean all these ritualistic people, Odinism, heathenry, So if one thing I can say out of all of this stuff is that I've gained a lot more knowledge in things that I had no clue about. Whether it was prison, whether it's Travis coming on talking about lawyer stuff and stuff like that, or whether it's Odinism and stuff like that. I love learning new things, but just meeting at the time, Odinism, I've heard about it many times, just didn't know nothing about it. And I kind of steered away because people are talking about masonry and all this stuff. And I'm like, don't hurt my brain, people. Like, what is this shit? I have no clue.
One of my outside interest is religions and things like that. And one of my giant pet peeves that I've had forever is the whole satanic panic, and then also treating, at least for people in the U.S. and especially like in the Bible Belt areas, treating like non-Judeo-Christian beliefs like they are evil. So then anything you come across is satanic and evil, and obviously could do a ritual. So that's like put an extra level of annoyance on top of it for me.
So let me ask, since I've got you all on here, and you can. My take on the Odinist thing was, I understand it was part of the Franks memo, but one of the initial things that caused me some concerns about the judge, and when I had an opportunity to read the transcript, so let's put the Odinism or whatever it is in the Franks, let's set that off to the side. So there was a motion to transfer or motion to amend the safekeeping order, and there was a photograph of Richard Allen and some dispute about whether, that was fair and accurately portrayed as what it was.
Right.
And then there was some things about Odin patches, and then that ended up being, well, you were untruthful about what you were claiming as part of that. And one of the things that caused me concern was, wait a minute, these guys came in and filed affidavits, the warden or superintendent, whatever they're called in Indiana, saying, no, those aren't Odin patches. I talked to these guys. They're Northern European pagan, whatever.
Yeah.
And I'm like, what the fuck is a prison guard wearing a patch? So to me, it was like, what the hell,
Yeah, rightfully so.
Let's separate these things. And why isn't the court outraged about that? Why isn't she demanding that warden to come in and asking, what the hell kind of operation are you running here that you have guards running around? Because the thing, getting back to learning new things and whatnot. So yeah, there's Odinism, but Odinism in the US started with a lady from Denmark. I just learned this recently, Elsie Christensen. And she was an Odinist, white supremacist that came over here from Denmark. And she was able to get this philosophy, I don't want to dignify it with a religion, of Odinist in U.S. prisons where it spread. And it focused this brand of Odinist, they're right wing and racist, and then they tie it in with theological things, but it's for the purpose of being able to say, oh, well, this is my religion. Which is why uniforms are uniform. You're not allowed to have a Star of David. You're not allowed to have a Christian cross. Not allowed to have a Catholic crucifix. you're not allowed to have anything on a uniform unless you're a chaplain, and then you get to wear the chaplain symbol. But other than that, no. And that, I mean, that would never happen in Texas, where you had guards that were wearing those kinds of patches and things. It just was really, really shocking to me. And then there is a brand of Odinism that is a legitimate religion, and it's a part of paganism, where, I think in North America, the word pagan, well, it was, what was that movie? Dragnet, and they went with Dan Aykroyd, and I can't remember who his co-actor was, but they went to the pagan feast, right? They're wearing that garb, and and so I think and I was in that big case where, in the middle of satanic panic, that got those 3 boys convicted because everyone thought they were Satanist and so on and so forth, and there was confusion between Wicca and Satanism, and I think there is a lot of confusion on that. But I think there's a great deal of confusion just what it is, Odinist in the prison system versus Odinists who are really part of the pagan religion, and it's complex and it's complicated. And
from my understanding, the majority in the U.S., at least, the majority of Odinists are the white supremacist type, and there are and this is where it gets complicated, and people are like, well, they had Odin patches on, so obviously they're Odinist. And while that might be true, it's still possible that they're not, because you can also be a Norse pagan,
right?
Because one of their gods is Odin, and worship Odin.
Norse pagan, yeah.
So, but most people who call themselves Odinists from tribe scene are the prison gang type.
Right. And the research I saw was that's what, they, look, if anyone's kind of questioning you on this, never say you're an Odinist, even though you are an Odinist and you believe in these things. Just say, I'm a Norse paganist.
Norse pagan. Mm-hmm.
And so then the question becomes, okay, are you really a Norse paganist, or are you a Norse paganist disguised as an Odinist, or vice versa, but that's why you don't allow patches. And it's just a fundamental,
it's just a no-no.
Fundamental thing. I'm wondering, do they have Caucasian white guards with the white population and African American guards with the African American population? Do they have Hispanic guards with the Hispanic population? I mean, I don't know. I know that there are groups like that in Indiana and Illinois, and to this day.
I will say that one of those guards in question, I think it was Robinson. That too, but I think that's Jones. Robinson, though, I went and looked at his Facebook, and I'm fairly confident that he is not one of those Odinists. I think he's just a pagan. And the reason I say that, he had like a Black Lives Matter fist on his on his Facebook, and like things like that I don't think one of those people would have. Now Jones, I don't know as much, but
and we talked about that when their names first got mentioned, because the BLM post where I immediately was like, I was like, I don't think this is a white supremacist, because most white supremacists don't, when their name is not brought out publicly, do they post pro BLM things on their social media? So the Robinson thing, I agree with you, ID 100%.
If you go back, I think both the because when I first read it, it sounded like there was like 2 patches, and so 1 patch for each of the guys they mentioned. But when I went back and read, I'm pretty sure that both of those patches supposedly belong to Jones, who is the guy who got the tattoo
Right.
and is a little more into it. And
And-
I would be less surprised if he was actually an Odinist than.
Right.
And I'm not making excuses for these people, because I think there's nothing more disgusting in the world than racism. But I do understand, having grown up in a small town in the Midwest, I
Yeah.
understand there is a level of ignorance
I see it, Travis.
that goes into some cultural things that people like and appreciate. Like, I grew up in Illinois. Illinois is a state that was part of the Union when it came to the Civil War. I have never in my life, I live in the South now in North Carolina, which was part of the Confederacy. I've never in my life seen more Confederate flags than when I lived in Southern Illinois. And it was not, it was not presented to me growing up as a symbol of racism. It was presented as, basically, I looked at it as almost like people that were just redneck or hicks. And I don't mean that negatively, even towards people that, display that stuff.
They usually say pride, not prejudice.
But, and so when I look at some of the stuff with the Odinism thing, I can see this correlation between this like Sons of Anarchy culture and this like the Vikings culture and Thor, and they don't understand the significance or the meaning behind some of what they're displaying. Some of them do, but I do think there's an element of just uneducated pop culture stuff that they get confused with some of it. And I'm not saying everyone, because I think there's some people that do it absolutely for racist reasons. But I do think there's some people that look at the stuff that are like almost like the Undertaker and Punisher stuff, and they're like, no, they don't look at the meaning behind some of the stuff. They just look at it as like, that's cool, and they go with it.
I would usually agree with that. I think those people would, and this is like splitting hairs again, but I think most of those people would go towards the more generic, like Norse paganism, because from what I've seen online, at least, Odinists tend to be very open with their belief of racial purity. Like, that's why they kind of use that. It's that European white people. But at the same time, when, who's the giant guy in the Franks who's like 6'7" or whatever, friends with? He was on Sleuth's channel.
Oh,
Westfall?
Yes, Westfall. He would tell you he's not racist. He would swear to you he's not racist. And
A lot of people would.
but at the same time, when he was asked, what do you think about interracial relationships? His answer was, well, polar bears and brown bears, they don't get together, which I don't know how this man has never heard of a Pizzly bear. They most definitely do breed and have hybrid babies.
To me, that's an example of ignorance. It's like they don't even realize they're being racist.
1 second.
$7 Australian and 99 cents. Thank you. Thanks for
Australian.
all your hard work today, everyone. And thanks to Travis for great legal advice. 20.
Appreciate that, Brown Skittle.
Skittle.
Just wanted to let that play out. Yeah. On its thing. Thank you so much.
Grant, red Skittles are still my favorite.
White, blue, red. I don't care. Whatever. Not brown. Okay. No, actually, sorry. Let me take that back. I love brown Skittles.
Green M&Ms are my favorite too. Sorry.
My nose just go. Yeah. Brown Skittle.
Brown Skittle had some great questions throughout the day.
Yeah.
Thank you, Brown Skittle. Appreciate the shout out and hope I answered your questions earlier.
It's Aussie.
This is Buddy. He's about 1 that we rescued.
What happened to the Mohawk?
Buddy's nickname is Boudreaux.
For Odin.
But
for Thor.
Buddy said he's taking exception
with black dogs
And white dogs?
hooking up with white dogs, and
I get it.
he,
Salt and pepper.
you know, he's got a lot of different varieties, and he's got a little mustache going on here, but he looked at me about the comment about polar bears and brown bears, and he
He's
looked
like,
at me, and I said, "Don't worry, don't worry."
I've got a whole running backstory about my pets. Like, I have a white cat with blue eyes, so I always say he's like a racist Aryan. And then I used to have a black dog with like brown markings, and I'm like, he's racist against Rocky because he's black and brown. And I thought I was the only one who said things like that.
That's funny. But I was gonna say I only got a couple more minutes, guys, because my husband's gonna need to go to sleep. He's had a long day at work. So actually,
poor baby. Like, Sonny, does he not know we've been on lives for like 10 hours?
Hit the switch on that. That air fryer? Throw in some chunks of fish. Hit that switch, and I'm going to be there. I'm going to be there in July.
Yeah, that's right.
Sure you have that air fryer down to a science by the time I get there.
Like he had to, what did he have to drive through a bunch of snow this morning?
Yeah. It's more like slush.
Right?
I'm so glad our snow is gone. I hate snow.
Ours is still here, but it's washed away mostly, like on the roads. Yeah, I love looking at snow.
We haven't gotten any because of corruption.
Yeah,
always. But let's do final thoughts, you guys, because it's been 3 lives today. It's been a long day, and so I said to husband, I know Thursdays are night, like Tuesdays and Thursdays are mine and my husband's night.
Well, and Sonny, tomorrow morning before you get up, or maybe before you go to bed, there will be my case filings.
Yeah.
Case.
Right. I know. Right.
We'll see a flurry of filings coming up.
All I know is there's Travis. Look at Travis. He's just morphing all over the place. I mean, he's in one room, then he's standing up, then he's in a different room, then he's standing up again, sitting with his dog. Now, where are you, Travis? So you just tired of sitting down? Want to take the dogs out?
I'm in the kitchen standing up. I have to stand up every once in a while.
Yeah. Well, I was going to say, do you have any final thoughts before we go? Besides, of course, thanking you.
No, just thank you for having me on earlier today, inviting me, and thank you for having me back. And hope we got some questions answered. And I really enjoyed it as always. And
yeah, sorry about your judge friend there too. Eh?
What's that?
Sorry about the judge friend that you knew, Carnes.
Oh yeah.
That, by the way.
What a sad deal. Yeah.
Yeah.
And then I went to law school with the husband of Mary Kay, the judge in Holthus, and
Mary Kay, the one that got attacked.
Yeah. And then turns out I got some close contacts on that tragedy down in San Antonio. They announced they're going to go the death penalty on that. The boyfriend and the pregnant girl.
Soto. Yeah. Gura Soto case. Yeah.
Have they announced if they're going to do it? But yeah, everything's kind of within 3 degrees of Kevin Bacon for me lately. But yeah, thanks for having me. That's my final thoughts. And
you better watch out. People will start saying you're involved if you have like Facebook acquaintances with those people.
Yeah. Drama. But anyways, no, thank you so much, Travis. Appreciate. And then I guess we'll just, like I said, see when we get documents by. I am expecting some documents to pop up tomorrow.
Absolutely.
Are you too, Travis? Like, would you expect documents to start popping out tomorrow?
I expect a 70-day speedy trial certification, possibly a motion to withdraw by the 2 new ones.
Right.
And then possibly a notice to reinstate the Frank's motion with memo and the motion to exclude the ballistics. But I really think that maybe let that wait and settle. But
Mhm.
it's day by day that I'd be
Yeah.
surprised if they hadn't filed it after hours electronically and it shows up first thing in the morning. But we'll see.
Sometimes yeah. I mean, there's times, like, strangely enough, there's times that it will be a Saturday, like, and then all of a sudden I'll see like a docs pop come up saying like entry minute and something like that. And like it will be like late at night. And I'm like I said, for me, it's like, either late Friday, for instance, or Saturday sometimes. And I'm just like, who's doing that right now? When a docs pop comes out like that. So I won't be shocked too if because sometimes, Travis, for me, and maybe it's because of you guys, I'm Pacific time, but sometimes at 3-4 o'clock, about 3 o'clock in the morning, 4 o'clock in the morning, yeah, which I guess would be 7 o'clock there. All of a sudden, poof, my docs pop goes off. I guess I'm thinking of it differently because I'm Pacific time, so I'm like 3 o'clock. What's going on at 3 o'clock in the morning? But really, it's like 6 or 7 there on there. So yeah, it won't shock me either. Anyways, Ivy, do you have anything? Anyways, thank you, Travis.
My brain is kind of fried at this point. It's just been it's weird. It's been like a crazy day, but at the same time, nothing too crazy happened.
Yeah.
I guess we will just see what's going to happen as we go forward. I guess my last thought is that I hope that that Rosie and Baldwin and Gull are all able to just put all this behind them and go on trail.
Yeah. I feel like they, will be able to. I think so. It's probably more awkward for the public than it is.
Yeah, it sounds like that's going to be the case.
Yeah, like Travis was saying, or other lawyers have said, they've taken ass whippings from judges and different things and whatever, and then go back in there. So I hope it turns out that way. I just really want the trial to get back on course, and get going with it, and let's get to the point where we see the day in court. And I am scared though. Like, I do wish. I want to say this actually. I do wish, Travis, do you want cameras to be in court for this trial, or do you wish that, or do you feel like that you're hoping that they don't?
I'm really not going to touch that with a 10-foot pole because, well,
5-foot pole?
there were not. So on Casey
How about
Anthony,
the Richard Allen poll?
there were not cameras in the courtroom, right? But everything was available under the sunshine laws. Is that correct?
Yeah.
All of the everything that was available in discovery was available to the public in Casey Anthony case. But the trial was not televised. Is that correct?
Casey Anthony, I didn't.
It was televised. I watched it.
Yeah.
Oh, okay. So that thing really put a bad taste in my mouth. Sometimes because of the amount in these high profile cases that get a lot of attention, it's, I guess it's not too bad. It's the court TV and YouTube and whatnot. There's a certain audience for that, but local press and media can just really kind of sometimes develop into a mob mentality and
Right.
people not really thinking critically and so on and so forth. So I have mixed feelings about it. I know that cameras in the courtroom, going back to, I think, the first court TV trial that spawned that network to begin with, was
OJ?
the what?
Was it OJ?
Who?
Was it OJ?
No, it was Kennedy Smith,
Yeah.
down in Florida, and Roy Black, one of the greatest criminal
Yeah.
trial attorneys in the country.
Brilliant man.
And
His wife Leah.
so, and remember the graying out of the victim, and but that spawned it all. And I understand, it's the genre. It used to be books and documentaries, like Thin Blue Line was one of the first ones. And then, the book Truman Capote and Cold Blood really exploded the genre. And obviously having cameras in the courtroom create an audience, and, allows you all as hosts to do what y'all do, and allows your community to grow and learn. But I just have mixed feelings about it that I haven't fully resolved. So long answer to an easy question, but that's my answer on cameras in the courtroom. I'm still struggling with it.
Yeah. Selfishly, yes, for me. Selfishly. But do I feel like it's possibly not in the best interest of the case? Because of, you said, like, this mob mentality and how it goes. So I too am kind of like torn, because selfishly I want to see every little droplet.
Well, let me ask you this, Sonny.
Yeah.
At this point, at the point we're at with Delphi,
Yeah.
a lot was kept very close to the vest, as ISP would have said.
Yeah.
Prior to the leaks.
Yeah.
But with the information that's now been publicly released about the Delphi case, what disadvantage would cameras in the courtroom have?
For me, about the disadvantage for cameras in the courtroom would simply be is that it becomes a circus in cases like this. It becomes a circus act. Because this is there's cases that come along, and
Right.
they're not even close
You don't
to
think
judging.
it won't be a circus
Is it-
without
I was-
camera?
Is it going to be a circus either way? Because that
No,
I'm
I don't
like,
think it's
I've
going to
used-
be the same if you
like,
can't see it.
today there was
No
cameras-
circuses in federal court. I guarantee you that. No circuses are in federal
Right.
court.
Like
I
today,
We're not in
today there
federal.
were cameras. Was there a circus today? Like,
That's what I was gonna ask.
No, but that's, to me, this is what's totally different than literally watching the Delphi case.
Yeah,
To me, this
law
is
nerd stuff.
I just see it as this, meaning, again, I for one would love to see every droplet on cameras, seeing it. But do I feel like it's healthy for the case in general? I don't know. I'm mixed. I don't know if that's the best thing, the best route to go.
So
Right.
another fundamental problem I have, and I'd like to get Ivy's response to this, is, and I've mentioned it before on here, the kind of cases that become huge, like Delphi, Jean-Benet Ramsey, it's young,
Thank you, John.
attractive white girls.
Mhm.
You don't ever see a bunch of outpouring of support, emotion on. Well, I take that back. I think all of the girls and women in Long Island were prostitutes. That's going on, and
It's fairly uncommon though.
yeah, I think that's big because it's a serial killer, but there's kind of a component on stuff that goes unsolved, and then you get a bunch of people in, trying to solve it. But by and large, the victim fits a certain profile, and this isn't something I've come up with. There was a bunch of outrage in Atlanta that thing wasn't getting solved because all of the victims were African American children. But that's kind of the other thing I struggle with in the genre at large, that why aren't we identifying with some of these other kind of cases where the victim maybe not look like us so much? Why isn't there the same interest? It has nothing to do with you all as hosts or other hosts.
YouTube,
But
YouTube and
else.
podcast cover those cases 10 times better than the regular media does. They're not. They're the like YouTubers and podcasts. They're not to the level that they should be at, but they do 10 times better covering cases like that than the mainstream media does. Covering cases of non-middle to upper class white women and girls. Like the Florida case.
I wouldn't mind the cameras if everyone could be level-headed about how they represent and deal. You know what I mean? Like, we just want to talk about the truth, present the facts in a sense and stuff like that. Not get into all this drama. I think it's because I think of all those channels that literally take everything and they ride it to the hilt. And so with cameras in, then it just is going to create this bigger atmosphere.
So people are going to go, they're going to pack the courtroom. They're going to do whatever they have to do, including maybe like recording it illegally or against the rules or whatever. Then
it's not the same as seeing it.
But it's going to filter through them.
It's not the same as seeing it though. If you don't have access to seeing it, you do not have that same vibe.
I disagree. I don't know. Maybe some people.
I guess
feel like
go ahead, Adam.
I feel like it can also intensify the frenzy, like you saw in the Johnny Depp trial, where people were trying to sell their seats in the courtroom. And yes, there were cameras in that courtroom, but people wanted so badly to be physically a part of that case and to be in person that they went to that trial and they tried to purchase their way into the courtroom. I mean, I know someone that went to the October 31st hearing of Rich John and flew across the country from California to be there. So, I mean, I know that people, will do what they want to do to be physically in person.
It's kind of off track, I think, to what I was saying, though.
And I think the fact that there were cameras today is one of the reasons why we didn't have that same situation at this one.
And that was my point, is I think, it can go both ways.
You're right, and it can go both ways. It's one of those things is like when you don't visually get to see something, it doesn't have the same impact. And it's truly, to me, it's not about the good channels out there. Like my whole thing about the cameras, it's more about these leech sucking channels that create something, whether it's a movement. Did he move his foot this and let's turn it into this big circus because that's my always
but that's gonna happen forever.
But visually, if you don't get to see it, you don't get to see that, so it causes
to me the bigger question is that I feel like we're at a point in our society, in our culture, where we have more possibilities of ways we can witness things that we weren't able to do in the past. Meaning, our courtrooms have always been meant, and Travis can attest to this, our courtrooms have always meant to be open and accessible to the public. But the definition of accessible to the public and open, that's the interesting thing to me, because now that we live in the era of social media and things, what does that mean? Because, does the public have the right to, yes, they have the right to physically go and be a part of a court case and sit there actual behind in a seat. But does that then constitute that they have the same right to sit at home and watch it on TV or on their phone or on an iPad?
In my opinion, the spirit of the law is if the public is able to attend, then there should be video in all the courtrooms, because the spirit of the law is that the public can witness our justice system working.
Right. Well, and
Hey,
that's and that
you guys
I
got
think
more
that's
than what we do in
a
Canada.
fundamental question. Sorry, Sonny, go ahead.
No, I was just saying, like, I mean, trust me, I appreciate all this shit. Considering we live in Canada and you don't see all this stuff going out, you'll see like little tidbits in the news, but you don't get to have access like this with juries and stuff like that, and watching it full blown, and which I don't like. I like that we can do that. You know, my only apprehension was, the circus act that revolves around some of these cases that gets to like ridiculous.
I
And
get what you're
that's
saying. It is a problem.
yeah, and that's what bugs me about it all. Like, meaning, like I said, so if it wasn't for that, that's the part that bugs me is how these leech sucking channels just literally ride off of everything, a movement of this, of that, and they turn the case upside down into a joke. And versus I mean, it's not a fair world. It's never going to be, and it's only going to get worse. So yes, I want to see it. I definitely do. If I had my choice to pick between that, I don't know that Fran Gull, if she's still stays on as judge, or and nothing else happens to her and she still stays on, I don't think she's going to allow them. I bet.
Well, remember, she helped partner the pilot program.
I know that, but after that little spiff that about you, like that wasn't supposed to be recorded, and then she denied what isn't it cameras after that or whatever for the 19th or well, no, that was the one
cameras, but the court should be the court's cameras, kind of like I guess the cameras were today, where they have control over like what they do with the cameras. So there's not like the media where they zoom in on somebody's face and all that stuff, and then they can the crime scene photos, for example, like if those are shown, they can cut those out or whatever. But anyway. I still think that that the public should have access to, at least, even if it's just audio, to at least listen to what's going on.
Well, having those cameras, so like today, and thank you all for your comments. It's caused me to like rethink some things. As I've said many times before over the last few months, my thing about being involved in this thing is to educate people. Not in it to have a channel or shout outs. It's to educate people that if you don't insist upon the defendant, despite what you think about them, if you don't insist that they have excellent trial counsel and that their rights are protected, even if that may end up being what's phrased a technicality, the whole system fails, all of it. Presumption of innocence, right to counsel, et cetera, and cameras in this appellate court, the highest court of the state of Indiana. This was a great opportunity today because channels like this, that in depth, trying to have good legal commentary about the way this thing evolved and free exchange of ideas. Should she have removed them on the 11th or whatever day, 11th, 16th, and then, the 31st? But everybody with your community kind of took that ride. And so it made that Indiana Supreme Court hearing extremely interesting today. And it made for a community, your community being very informed, because you could tell by the questions, very informed, listening to those hyper-technical questions and hyper-technical responses. But everybody, whether you're a lawyer or almost a lawyer, don't want to be a lawyer, could follow along to a certain extent. I think with very few exceptions, nobody was lost in general about what they were talking about. So my point is, I was able to, what a great trip it's been. I reached my goal in being able to educate and hopefully get one or two people that may have been, oh, he's guilty, he's guilty, he's guilty, to thinking, okay, well, wait. We need to make sure that he has his counsel of choice. Otherwise, this could be a show trial. That we need to make sure his presumption of innocence is preserved, and we can still talk about what we think and so on. But we would have had a completely different experience. One, you'd have a completely different experience if you were there live. It's like anything else. There's just no substitute for it, whether it's a football game, an oral argument,
Right.
a concert. But the fact that it was televised and that they had excellent people, they clearly are court people, not media people, running the video, but they were technically great at it. Close-ups of each judge, going back and forth to the litigants, to who's speaking. I mean, just superb job on the production. And, having all of that and have it develop was absolutely wonderful to be able to, fulfill my goals. But that's...
Yeah, and we got to, like, on what you're saying there too, and I agree when I'm thinking about this, is that if it was closed and we weren't able to watch it, we would be thinking, like Adam kept saying all day, I think something like, like he appreciated, well, we all appreciated hearing the questions, that we know that this was a fair balance, oral argument going on, and we got to see that, and then for ourselves, so we got to experience that. Now, if it was closed off and we never got to see it, we'd be sitting there. I'm sure there would be tons of stuff, even like a lot more stuff being said, because you don't get to see any of it. So I think that this really truly did allow for us to go, okay, they did a fair job, and then they came to their conclusion, and and they basically put questions to both sides, and again, they came out with the decision. And now, and because we all got to watch it, we can go, okay. Most of us will go, okay. That's what they decided. It was fair. Both sides had their chance to oral arguments and da-da-da-da-da. So I really did love the process of this. So, again, it was only the circus act in my head that always bugs me with this case. It's been such a circus act for so long. That's what my apprehension is with
I have one more argument for you, and then I have to get off because I took...
No, we got to go. I know.
Me too.
An hour ago. My short last argument for that is, even after the trial is done, like we were talking about earlier today, people are going to request all of those records. They're going to get them. So no matter what, at some point, people are going to get to go through tiny detail by tiny detail, and the circus will happen no matter what. It just depends on when. So we might as well be able to watch.
I get it. Okay.
Kind of, since we're here, Ivy.
Yes.
Since we're here, I agree with that. So it was great. Everybody kind of got to see how we make sausage as attorneys, and if we didn't have even the audio, the live audio, if we didn't have that, then we'd have what we rely on the Supreme Court. And so you'd have people like Bob giving his recap of what happened and he admits it, from a defense attorney's perspective, through that eyes, those glasses, he's looking through it. Others from other perspectives. And so you got to listen to all these things, and like you said, Sonny, you don't have to rely on anybody. And so you end up getting educated community. We do the best we can yesterday and today, kind of briefing them on how it's going to happen. Because I bet very, very few people have listened or watched an appellate argument before, because it's just not interesting unless you've followed this thing along and you know. And we had people saying, "Oh, I hope she does. I hope they don't get reinstated. I hope they're reinstated. I hope Judge Gull is gone. I hope that Judge Gull stays on." And it's okay to have differing views about that. But you all got to see the thing from literally start to finish. And then hopefully people got to understand and be educated about, as difficult as it may be for somebody that we talked about, and then I'll shut up, but that gross negligence, it depends what they're grossly negligent about. Releasing or violating protective order, clearly wrong, but what needs to be looked at is something that rises to the level of ineffective assistance of counsel, showing up to court drunk, missing court appearances, and other types of things. And so now they know, and even though they may not agree or they think there should be some penalty, I've saw a lot of people over the last few days in comments saying there should be some sort of sanction against them, and be that as it may. But now they understand that, hey, look, the court's looking at something very, very specific. And even though I don't agree with it, I understand why. There's a fundamental right for a defendant to have appointed counsel of his choice, unless it's seriously impacting his defense to the point where he could get a new trial and post-conviction relief. So it's just been a really wonderful ride, and thank you all for having me join the journey for this part of it. Appreciate it.
And it's definitely not pro bono, Frank. It's public defenders that they would be reinstated back as. Correct? I mean, to me, that pro bono was off the table, and that
I think it was in the actual order. But I've got to get off here.
Nope. Let's go. Travis, thank you. Adam, you probably just want to get off now, I'm sure.
Yeah. Right.
Did you have a last comment? I just have to ask you, of course.
I just appreciate everyone for all of your time today, and Travis, Ivy, for spending so much time with us and giving us your opinions and your expertise. And in Travis's case, his qualified attorney opinion and expertise, not just his almost.
Yeah, not just almost a lawyer expertise. Anyway,
I appreciate it.
Yeah, thanks, Frank. Thanks, Charmaine, Travis, Ivy. Again, it's been a great 3 lives today. So just a lot of information today or stuff. Anyways, it was a really cool day. So thank you guys very much for your time. Thank you for anyone.
Catch you guys later.
Yeah, for super chats and all that stuff. Have a good night, everybody. We're gonna head off here. Oh yeah, she just left us looking all good, didn't she? Anyways, we're gonna play the outro now, and we'll see you tomorrow night. Okay, guys? This is Sunny Justice and Aspen Connor from It's a Crime and Shame, wishing you all a good night.